First of all, happy New Year to your Lordship.
Thank you. Same to you.
Thank you. Now, may I pray for listing of an urgent matter up to today yet?
Today,
Today, also, because there is an injunction order against holding of a meeting on 5th of this month, day after tomorrow. That is why it is very urgent. Apply.
That is. Civil division petition, it is pending case, my lord. We have filed an application for vacating the stay order. So, my lord, it may be on 10th of January, my lord.
but how can you implicate the judicial officer as party?
Oh, that is,
Do you know the law?
my lord. That is other thing, right? It is
You withdraw the petition, otherwise we will impose heavy costs upon you.
no, let the come, but it is not that, it is another matter, my lord. Yes, I have seen, my lord. That is item number.
You file it intentionally as a contender number 1.
One, yes.
What contempt he has committed?
That is, my lord. Actually, order passed by the Honorable Court and to submit them, my lord. It was submitted before him, my lord, but he has only said, inform all them. And now,
You withdraw the petition. Otherwise, you will face the consequence.
my lord, let the matter be the withdraw, my lord. That is like item, my lord, 12, 16 item. But I have not bring the file till now, my lord.
You want to withdraw today?
Well, today itself.
Mr. A. Rashid, learned counsel for the petitioner, submits that he may be permitted to withdraw this petition. There is allowed this.
Well, with liberty,
Dispose
maybe.
on withdrawal.
Now, liberty, there is some other party is there, so liberty may be granted to file a.
However, liberty will remain with the petitioner to approach this court again by filing a petition.
And this may come up for the order on Friday.
Next Friday.
Yes, next Friday. Today is Friday, next Friday. Friday for order for vacating this.
10th.
Yes, 10th.
May I please, Lordship? I'm paying for listing one RSA matter 11/2013. Earlier, it was mentioned in twice in this before this honorable court, Lordship. It was allowed also, but not yet be listed. RSA
When do
matter
you want?
9/1/2025, Lordship. Thursday.
9-1. Okay. Okay. Yes.
Lordship, I would like to mention for listing of IS Civil 2099 of 2020. My lord, actually this case I have mentioned many times, but then execution case is in the progress.
When do
So,
you want?
if possible today in the it's like
No,
now.
not today. Not today.
Tomorrow we have got the execution.
Tomorrow is
Tomorrow is Saturday, so we have
Monday.
Monday. Okay, Monday.
Yeah, please, Your Lordship. Your Lordship, I beg to mention for the listing of one RS 29/11. Since 2023, Your Lordship. is
Not been
on
listed.
schedule.
When do you want?
Next week, any day.
Okay.
So under which column? Under which column? Orders, hearings
Orders,
on 22nd
22nd.
after view.
May I please, I would like to mention one MSC appeal, so delay condition petition, it was not explained properly. There is you lordship asked to file additional affidavit. It has been filed months before vacation. So it may come under order columns on 10th, lordship. Yes. Thank you, lordship.
Lordship, I have to mention one motion matter. RSL.
When?
Next week on 7.
Okay.
Please, Your Lordship. Lordship, I pray for listing of a CRP, I remember. The matter was last listed on 13
When do you want?
on Monday, my lord.
Monday.
Monday.
Okay.
Published.
May it please the Lordship, I beg to mention 2 MSC appeals for listing on 9/1/2025 for orders. May I please the Lordship? I beg to mention item number 1 to adjourn the matter for today, as my senior is out of station.
Who is your senior?
P. Mahanta,
Your good name, please.
C. Sharma.
Ms. C. Sharma, learned counsel appearing on behalf of Mr. P. Mahanta, learned counsel for the petition. Praise for listing the matter on
On Monday,
Monday.
apply search.
May I appeal your Honor?
Yes.
I pray for listing an MSc appeal your Honor.
When?
For admission.
When?
Lordship, 9 or 10.
After Bihu,
After any day
on 22nd,
earlier.
2020. Just after Bihu. After Bihu vacation, 20.
May I please, Lordship, I beg to mention item number 7. Matter may
Yes.
pass over for the day, Lordship.
Yes, on the pair being made by Mr.
Alum.
A. Alam, learned counsel for the petitioner, raises the matter on when
7.
Seven.
Developers.
Mate, Lordship, I beg to mention item number 4 and 10.
item number 4.
4 and 10. Lordship, item number 10 maybe after 1 week, Lordship. Before
Item number 4 and 8.
10,
4 and 10.
Lordship.
On the pair being made by Mr.
R Islam, Lordship.
I. Islam.
R Islam.
R. Islam, learned counsel for the petitioner, raises the matter on when do you want?
Lordship, item number 10 maybe after 1 week, Lordship.
After 1 week. Item number 10, 1 week. Then item number 7.
Lordship,
Oh, 4, sorry.
item number 4 immediate after vacation, Lordship, due vacation.
Due vacation.
Yes.
Okay.
Yes, Lordship.
Motion item number 2.
May I please, your Lordship? My lord, here in this case, I am the plaintiff. I filed a suit for tenancy right, my lord, and for injunction and not to disturb the electricity connection, my lord. In that suit, my lord, the respondent herein filed written statements along with counterclaim. In the counterclaim, my lord, they are prayed for that I am the defaulter, as well as the suit premises is required bona fide. The trial court, my lord, initially decreed my suit and dismissed their counterclaim. Then in appeal, my lord, it has been reversed. In appeal, it has been reversed. My lord, kindly see case 53, my lord. Because in the reversal order, my lord, only on the point of defaulter has been, the suit as counterclaim was decreed. So far, bona fide requirement is concerned, it was upheld with respect to the findings recorded by the learned trial court. So we are only confined with the whether the petitioner was defaulter or not. Page
Let
53.
notice go at this.
Yes, and in the meantime, my lord, stay. Otherwise,
Where is your stay petition?
no, in the civil division, we are making prayer in the civil division itself, my lord, because it is a petition, my lord. In the prayer is there, my lord. Page 14, my lord. And I am also make amendment in this regard, paragraph 12.
At what stage the suit is pending?
No, in appeal it was reversed. Now it is finally
Gotcha.
disposed of. Appeal was finally disposed of.
Gotcha. Or Mr. Escapes learned counsel for the petitioner. His petition under section 115 and 151 of the Code of Civil Procedure, read with Article 257 of the Constitution of India. The petitioner has challenged the correctness or otherwise of the judgment and order dated 11/9/2024 passed with the learned civil plus Seniority number 2, entitled number 27 of 2023. It is to be noted here that by the judgment and order dated 11/9/2024, the learned first appellate court has reversed the judgment dated 21/8/2013 and the decree dated 26/8/2013 passed by the learned chip number 3, Kasar Silso entitled suit number 47 of 1990. Peruse the petition and the documents plus on record and also peruse the judgment and order dated 11/9/2024 passed by the learned civil plus Seniority number 2, Kasar Silso entitled level number 27 of 2023, and also the judgment and decree. Judgment dated 21/8/2013 and the decree dated 26/8/2013 passed by the learned Mochi. Number 3, Kasar Silso entitled number 47. Let notice be issued to the respondents.
Yes.
4 weeks that be taken by registered post with AD and also by the prosecutor. Okay. This will call for the records.
Yes.
The learned courts below. And till returnable that the judgment and order dated 11/9/2024 passed by the learned civil judge innovation for 2 Passard sector and title level 27 of 2026 that's state. List of the 4 weeks.
Item number 3. May I please your lordship? Lordship, I am before your lordship with the impugn order passed by the learned my lord, special tribunal Nagaon, my lord, in special case LG case number, my lord, impugn order dated 18/1/2024 at annexure 8, page 58, my lord, against which, my lord, the relevant portion, my lord, your lordship will find page 64 of the impugn order. Paragraph 13, my lord.
Page 60.
64, my lord.
Yes.
Paragraph 13, my lord.
Yes.
The injunction petition filed by the respondent, my lord, is allowed by the learned special judge Nagaon. Against
So
which,
you tell me whether appeal will lie against
my lord,
this order or
appeal lies, my lord.
dismissal?
That's why I am before. Appeal lies, my lord. But the appellate court has not been constituted, my lord, till date. That's why I am before your lordship. Against this order, special tribunal, my lord, the appeal lies, my lord, to the, my lord, special court, my lord. That has not been constituted. So I am remedialist, my lord, at this moment. That's
Okay. Let me-
my lord, page 14, my lord. Appeal 13. Section 13, ma'am. Any person aggrieved by the judgment and order not being an interlocutory order, the special tribunal may prefer an appeal before the special court or any question of law or fact, notwithstanding anything to the contrary contained in the Limitation Act. So and so, an appeal under this section shall be preferred within a period of 60 days from the date of passing of the judgment and order by the special tribunal. So, my lord, the special tribunal Nagaon has passed this impugn order, my lord, 18/1/2024. Against it, my lord, the appeal lies.
The question is can this court exercising the jurisdiction under Article 227 of the Constitution of India can entertain a revision petition against an order where appeal lies?
My lord. Yes, my lord, under Article 227 of the Constitution of India, this honorable court is jurisdiction.
This act itself provide for appeal.
Lordship.
The question is, can this court entertain a revision petition
My
while
lord,
the special court is not available?
as the special court is not available, my lord, the petitioner before your lordship cannot be remediless. He can approach before this honorable court under Article 227, my lord. Earlier, my lord, I approached, my lord, before this honorable court under Article 226, my lord. But
226 definitely.
my lord,
226 cannot be invoked against judicial
That-
order.
that has been withdrawn, my lord, with the liberty to file a press. Your lordship may kindly peruse.
No, you have been granted liberty. That's all right, but
after-
merely because you have been granted liberty, you cannot file a petition under Article 227.
My lord, at page 77, my lord. Kindly peruse, my lord.
We have to examine whether it is maintainable or not.
Sub- 77.
So here
But-
liberty is granted to you to assail the impugn order as per appropriate provision of law. Is it the appropriate provision of law?
My lord, then my lord, your lordship will be, your petitioner will be remediless, my lord. Where he will go? He cannot be remediless. Your lordship can exercise this power, my lord. Your lordship has the discretionary power, my lord.
No, no.
Article 227, my lord.
It is well settled that where appeal is provided, the court cannot entertain revision petition.
Exactly, my lord, where there is a provision of law, my lord, we cannot approach. But
You show any other authority on this point? We will consider it. We will adjourn the matter
my
till next week
then after vacation, my lord,
to the provision.
and a date may be fixed, my lord.
Third, Mr. T.U. Losker, learned concept for the petitioner, list the matter on for further deliberation on the point of maintainability of the petition.
Oblige, your lordship. Item number 5.
Non-appeals for the petitioner on call, list the matter of the petition.
Item 6.
May I please your lordship, my lord?
Yes.
The petitioner, my lord, is the husband, my lord.
Hmm.
And the opposite party is the wife, my lord. The petitioner has, my lord, filed a divorce proceeding, my lord, on the grounds of cruelty, desertion, and unsoundness of mind, my lord.
Hmm.
Simultaneously, my lord, the opposite party filed an application under Section 24 of the Hindu Marriage Act for the maintenance, my lord. Lord, my lord, the opposite party, the petitioner has, my lord, the case of the petitioner in the while filing objection is there, my lord. That's she's a government school teacher, my lord, and she's receiving, my lord, salary, my lord. And Section 24 mandates that, my lord, that when the wife or husband does not have sufficient income to maintain herself, then only she can go for, my lord, Section 24, my lord. Lordship may peruse Section 24 of the Hindu Marriage Act, my lord. I may be allowed to read, my lord.
Yes.
My lord, I may be allowed to read, my lord.
Yes, yes.
When in any proceeding under this act, it appears to the court that either the wife or the husband, as the case may be, has no independent income sufficient for her or his support and the necessary expenses of the proceeding, it may, on the application of the wife or the husband, order the respondent to pay the petitioner the expenses of the proceeding and monthly during the proceeding such sum as having regard to the petitioner's own income and income of the respondent. It may seem to be court to be reasonable, my lord. In this case, my lord, she's a government school teacher, my lord, having a my lord, salary, my lord. So she's not entitled under section 24, my lord, of the Act, my lord.
But this provision is interpreted by the Delhi High Court. The trial court has
My lord,
relied upon a decision
my
of
lord,
Delhi High Court.
My lord, lordship may peruse, my lord, does our high court, my lord. Yes. Paragraph 10, my lord. Page 6. I shall read, my lord. The law thus is very clear. A plain reading of this section makes it amply clear that the claim of the maintenance pendant light under section 24 of the Hindu Marriage Act, the spouse who moves the application must show that she or he has no sufficient income to maintain and support himself or herself. Obviously, the support visualizes a situation where the spouse is entitled to enjoy the same status as that of the respondent's spouse. Therefore, where there are great disparities in the income of the husband and wife, the court may have to bring about a balance between the two by awarding maintenance pendant line to the spouse who is earning a lesser amount. However, in my humble opinion, this is not done in the mathematical basis. The purpose is not that if husband is earning 10,000 and the wife is earning 5,000, then both are brought to the equal level of 7,500. That is not the purpose of section 24 of the Hindu Marriage Act 1955.
How this judgment will help it?
My lord, my lord, in this judgment, it is shown that my lord,
This was the judgment of the year 2016.
16, my lord.
Thereafter, in Supreme Court, in the case of Rajneesh versus Neha, had dealt with the issue.
My lord,
What is that
my
judgment?
lord, if my lord, she would have made an application under section 125 of the CRPC, my lord, she would have been entitled, my lord.
No. In the said case, every aspect has been dealt with by the Supreme Court. You produce that judgment, we will see.
Lordship, my lord,
We will release the matter on
Monday, my lord.
Monday.
Lord, hello.
Third Minister, your good name, please.
DK Borwa, my lord.
Learned from the Court of this petition under Article 227 under this application under Section 19 of the Family Court Act 94 is directed against the order dated 7/8/2024 passed by the Lord and Principal Judge Family Court Kasar FC is case number 3 of 2023. Arising out of FC civil case number 194/2022 is to be interpreted by the judgment the guide order dated the learned trial court has directed the petitioner to pay maintenance. Now, one time to make one-time payment of rupees 4,000 towards the cost of the proceeding and a sum of rupees 5,000 per month to the petitioner and another sum of rupees 7,500 per month to the debtor towards standard life maintenance of the petitioner stroke wife and her younger daughter Miss Priyanjali Ghosh till disposal of the main FC Civil 194 of 20. Lease the matter on Monday for further deliberation.
Hello.
Item number 8.
Yes.
This is a case of non-compliance of order of the district judge Kokrajhar by the DC Kokrajhar. A order has been passed on a reference case under Assam Requisition and
Okay,
Control of Vehicles Act 1968, my lord.
Okay, the Deputy Commissioner Kukurajar has written a letter to the government.
My lord.
The Deputy Commissioner Kukurajar has written a letter to the government for allotment of fund.
My
Right?
lord. That was not allotted.
Not allotted. Yes, Mr. Gogoi.
I need some time for instruction from the Deputy Commissioner. But it's actually
Why don't they file a execution petition there? Is there any provision for filing execution petition?
My lord, there is no provision in the Assam Assam Requisition and Control of Vehicle, not any provision, my lord. For
So whether
appeal, revision or execution, nothing else, my lord.
whether that award can be treated as a decree.
I do not find any judgment under whether it can be taken as a decree, or not.
Mr. Gogoi,
Lordship,
you obtain instruction
Lordship.
and make necessary arrangement for payment of the amount. See, this matter is pending since when?
98, my lord.
98.
Lord.
It's a long, so many petitions has been filed in the High Court itself.
Short date, Lordship.
Or Mr. D. Bhattacharya, learned counsel for the petitioner. And Mr. Gogoi, learned
Here goes.
government advocate for the state respondent. On the pair being made by Mr. Gogoi, learned government advocate for the state respondent to obtain necessary instructions. The matter is hence adjourned to be listed on Wednesday.
On 8.
Lord.
Item number 9.
Obliged.
May I please, your lordship?
Yes.
The petitioners before your lordship are the plaintiffs, your lordship.
Hmm.
Their cross-examination of 6 plaintiff's witnesses was closed, your lordship. Against that order, the petitioner before your lordship. Your lord. The impugn order, lordship, page 108.
Yes.
By order dated, your lordship, by order dated 12/2/2024, the evidence cross-examination was closed, and thereafter the petitioners filed an application under section 151 for recalling that order. And by order dated 7/9/2024, cross-examination was closed, your lordship. That petition was rejected. The operating portion, your lordship, page 110, your lordship. Operative portion.
How many adjournments you have already taken?
Lordship, after submission of PWs, I have taken 3 adjournments, your lordship. On lordship 9/1/2023, I have annexed the order sheet, your lordship, page 99. Kindly see, your lordship. Page 99. On 9/1/2023, the last PWs 13, PW 13 submitted, your lordship. Thereafter, lordship, next page, on 4/2/2023, I have adduced 8 numbers of PWs. 2 were cross-examined, and due to paucity of time, others were not cross-examined and discharged. And thereafter, lordship, 24/2/2023, 4 witnesses were present.
Three were cross-examined. Due to paucity of time, one could not be. Thereafter, Lordship, on 28/4/2023, I have taken time, Your Lordship, the petitioners, page 101. And Your Lordship, 25/2023, the petitioners took time, Your Lordship. And 1/7/2023, 26/7/20, 25/2023, 1/7/2023, defendants took time. And lastly, on 26/7/2023, plaintiff took time. And Your Lordship, on 12/2/2024, the case was fixed for further cross-examination of PWS. And on that day, they could not appear. And the reason behind this, Your Lordship, I have annexed the FIR copy. I was threatened, the petitioners was threatened, Your Lordship. Page 67, Your Lordship, kindly see.
Okay, we will grant you one chance.
Lordship.
Heard, Mr.
A.R. Shom, Lordship.
Learned Counsel for Doctrine. Order dated 12/2/2024, passed by the Learned Civil Judge Senior Division Durham, Mangalore, in PS number 10 of 2019. Is challenged in this petition under Article 27 of the Constitution of India. It is to be noted here that by the impugn order dated 12/2/2024, the Learned Trial Court has rejected the petition number T24/24 filed by the petitioner seeking another date for cross-examination of the PW. Mr. Sum, Learned Counsel for the petitioner, submits that on that day, the petitioner could not remain present in the court and also produce his witnesses on account of your FIR is at page number?
FIR is page number 67, Your Lordship. Type copy. Translated type copy.
Written by the respondent, for who is the petitioner that filed one FIR before the FIR with the officer in search of which PS
Kharupetia Police
of
Station.
Carpenter Police Station. And the said FIR is enclosed with this petition at page number
67. 67.
on 11/2/2024. And as such, Mr. Sum submits the order dated 12/2/2024, so passed by the Learned Trial Court, closing the evidence of the PWs is illegal and arbitrary and therefore contemplated. For a hearing at the submission of the Learned Counsel to the petitioner, I have carefully gone through the petition that is plus court and also perused the order dated 12/2/2024. It appears that the Learned Trial Court does not believe the where is that petition for adjournment?
Lordship, I have petition for recall, Your Lordship. I have page 72,
The
Your Lordship.
petition for adjournment.
Twelve petition is not there, Your Lordship. 12 petition. 12/2. Lordship, I have annexed the petition recalling the order dated 72, Your Lordship. Can you peruse page 72, Your Lordship? Recalling the order dated 12/2/2024, 151 petition. Describing the FIR.
Uh, this order was passed on the petition dated petition number 324 of 2023.
324 petition order was passed on 12/2/2024. Thereafter, Lordship, I filed a
No, that's all
petition.
right. You show me this, you are selecting this order 12 to 2020.
Lordship,
This order was passed on the basis of the petition filed by you. Take the petition number 324 of 24.
yes, Your Lordship.
That petition is not part of the record.
That petition is not there, Your Lordship.
You produce that on the prayer being made by Mr. Ayers, Garnet Council for the petition. That's the study of
Lordship on Wednesday.
Wednesday.
Wednesday, Lordship.
Wednesday.
Lordship.
Item number 11.
Oblige, Your Lordship.
I don't so enable him to produce the order, no, produce the petition dated no, petition number 324 of 2024 for this body.
Item 11.
Yes.
And I have challenged the order dated 7/5/2024, which is at page 45, madam. By which, my lord, the cross-examination of PW20 has been expunged. On that day, my lord, particularly, I sought adjournment by showing the ground, which is at page 39.
How many opportunities were afforded to you
Well,
to
so far,
examine
that
the
was-
asset?
No doubt, my lord, I have some lapse on my part also, my lord.
And for how many months you have not paid the rent?
So far, the payment of rent is concerned, my lord, I was regularly, my lord, paid, my lord. To that aspect, my lord, no such dispute has been arrived. And so far, my lord, my part is concerned, I was partly cross-examined. On that particular day, my lord, I went to my lord, native village at Bihar, which is at page 39, my lord. On that day, my lord, while I have to go to Bihar, my lord, I could not inform the PW2 and 3, my lord. That is why they could not appear before the learned court. Otherwise, they have.
Why you could not
Yes, my
inform
lord,
them?
page 39.
No, why you could not inform them?
My lord.
Why you could not inform them about the date?
Because I have to visit my native village at Bihar.
Bihar is not connected with Assam
No doubt, my
by
lord.
mobile network.
That's true, my lord. On that day, particular day, I could not my lord, inform them.
So
But subsequently, my lord,
since when this petition is pending and this case is pending?
my lord, case was pending, my lord. I filed a suit, my lord, in the year
When it was filed?
17, my lord.
17.
That my lord, COVID period has also, my lord, passed. During that period, my lord, cross-examination was in respect of my partly, my lord, concluded, my lord. What happened, my lord? Thereafter, my lord, PW 4 and 5, 4 also, my lord, cross-examined and discharged, my lord. 5 has not been completed, my lord. And so far, 2 and 3 is concerned.
That's all right. You show me how this impugned order is illegal and arbitrary.
Yes. But so far, examination, cross-examination, PW 2 and 3 is concerned, my lord. Lordship may take note of the Annexure C, page 39. For her, for his daughter's marriage, he went to my lord Bihar. I may read you, Lordship, that the plaintiff has gone to Bihar on 28/4/2024 for the marriage of his daughter. Due to sudden absence of the plaintiff, he could not inform the other witnesses regarding today's date of the court. As such, they also being out of station, and as such, they are unable to present in the court today. The documents, supporting documents have also been annexed, my lord. Under such the above plaintiff shall highly prejudice unless in his absence is condoned for today and some other date may be fixed for the cross-examination of plaintiff. My lord, now my lord, so far I have annexed the entire order sheet, my lord. Page starts from page, my lord, 47. (31/10/2023) was the first date for fixed for cross-examination PW20. Etc. my lord. Page 55. So far, my lord, conduct of the petitioner. No doubt, my lord, he has taken lots of adjournment in that suit, my lord. COVID
No,
period
no,
also-
this matter is being delayed by you.
my lord, so far that part is concerned, my lord.
The
What I
record is
insist that
loud and clear.
only to the extent that he should not be prejudiced by any manner. So far,
How
cross-examination
you
of
are
2 and 3
prejudiced?
is concerned, my lord.
How you
Already,
are
my lord,
prejudiced?
cross-examination of PW is going on, my lord. Only to the extent that they should
Sufficient
be,
opportunities were afforded to you.
my lord, so far,
You
my
have
lord,
not availed it.
cross-examination of PW 2 and 3 is
You,
concerned, my lord.
you show me the order.
Yes, yes,
How it is illegal.
my lord.
The order is at page number.
Page 45 is the impugn order.
Yes.
My lord, so far, absence of PW 2 and 3 is concerned, my lord. They were to be present in the court, my lord, on that particular day. But I did not inform. They are my witnesses, my lord. It was my duty to inform them. But because of my absence, I was at Bihar, my lord, at that relevant time due to busy schedule of my marriage of my daughter, my lord. That is why I could. That was my lord, skipped to get informed to the PW 2 and 3. They have no fault on their part to be appeared in the court below, my lord. Since I have not informed them, my lord, they could not appear, my lord. So far, my lord, marriage part is concerned, the parents has to be busy with maintaining the marriage, my lord. Somehow you just keep, my lord. For that, my lord, he should not be, my lord, prejudiced. Only one chance may be given, my lord. On that particular day, they will present. If they fail, my lord, that will be accepted.
You come to page number 35.
Yes, my lord. (35)
Paragraph number 9. Last part.
My lord, it is a counterclaim, my lord. They have to prove it, my lord. It is their counterclaim. They have to lead evidence, my lord, to that effect, my lord. I am denying that part, my lord. I am denying that part. They have stated something, my lord. I am denying that part. I have stated something. They have denied that part. That will come out at the, my lord, trial, my lord. That is why, my lord, my cross-examination, my evidence are necessary, my lord, to find out the truth. Only for the, my lord, last chance may be given so that we can be cross-examined. Only 2 and 3 are left, my lord. Okay, 4 and 5 are, my lord, already completed, my lord. One is
That's
also
all right,
completed.
but to interfere with the impugn
I am
order,
also, my
you
lord,
have
ready
to
to pay
show
some
that it
cost
is
for,
illegal or arbitrary.
my lord.
To show the arbitrariness in the impugn order.
So far, my lord, that part is concerned, my lord. The learned trial court below while, my lord, passing the order, my lord. So for my absence and the ground of, my lord, absence of PW 2 and 3 have not been, my lord, properly, my lord, explained, my lord. Also take note of the, my lord, order dated 7/5/2024. So for opportunity given to the, my lord, petitioner as regards to cross-examination of PW 2 and 3 is concerned, my lord. On perusal of record, third paragraph, my lord, page 45, it is found that since 3/9/2019, this is pending for cross-examination of PW1. On 31/10/2020, it was clearly stated that PW1 is unable to appear for cross-examination.
PW 2 to 5 will continue. Accordingly, today is fixed for cross-examination 2 and 3. Ground mentioned in the instant petition for adjournment on ground of absence of plaintiff is not at all satisfactory when today is fixed as last chance. Considering all above facts, cross-examination period 2 are closed. But so far that part is concerned, my lord. Whether the reason for absence of PW 2 and 3, which I have explained in my petition at page 39 is concerned, my lord. That is, my lord, not discussed, my lord. Because I have, my lord, categorically stated in my petition.
No, it is stated that the ground mentioned in the instant petition for adjournment on the ground of absence of the plaintiff is not at all satisfactory.
So far that satisfaction is concerned, my lord. I have categorically stated that on
So
account
that
of
has
marriage
dealt
of my
with-
daughter, my lord. On account of marriage of my daughter, I was absent. I was busy with my marriage of my daughter, my lord. That is why, my lord, I could not inform. It is possible, my lord. It is possible, my
No,
lord.
no. You have already been given the last chance.
My lord, so far the last chance is concerned, my lord. I have annexed the entire order sheet at page, which is starts from page 47, my lord.
When this last chance was granted,
27 to 2024.
20,
Page 55. 27 to 2024. On the very next day, my lord, prosecution has been expunged.
no, is it your submission that after the last chance, another chance also have been given to you?
No, my lord. On the next day, my lord, 27 to 2024, that was the order whereby the last chance was given. The next date was fixed on 7/5/2024 when the impugned order has been passed.
So how this
In between,
order
my
is
lord, 2
illegal
days, my
and
lord, there is
arbitrary?
no other dates, my lord.
You show me how this order is illegal and arbitrary?
So far, that part is concerned, my lord. For ensuring paramount justice to the petitioner, my lord.
No, justice has to be done to both the parties, not
Yes,
only to
that's
you.
true, my lord. But they are given the chance of cross-examining by witnesses, my lord. They will not be prejudiced by any manner. So far, cross-examination of PW 2 and 3 is concerned. If my lord, evidence is not taken, my
Why
lord,
prejudice is not will not be caused to the other side?
my lord,
The matter is pending since long.
my lord, so far the long pendency of the cases is concerned. COVID period is also, my lord, there, within that period, my lord.
Pardon?
COVID period is also within that period, my lord. Because for a long time that was not taken place due to the COVID protocols, my lord.
So that's all
Subsequently,
right.
thereafter, my lord, that was, my lord, continuing, my lord. Cross-examination of PW1 was also, my lord, taken place,
Taking
my lord.
into account that part also,
My lord.
your conduct is not at all satisfactory.
My lord, so far, that part
The
is
trial
concerned.
court has rightly observed
Yeah.
in the
So
impugned order.
so far, my lacuna is concerned, my lord, I am admitting to that. But so far, my lord, justice is concerned, my lord, my submission
no.
is such. My lord, so far, my lord, PW 2 and 3 is concerned, my lord. Only to that extent, my lord. Only 4 and 5 has been appeared and they will cross-examine, my lord. My lord, no opportunity, my lord, had been given to the, my lord, the defendants, depriving them to cross-examine the PW 2 and 3. They will given, my lord, ample opportunity to cross-examine the PW 2 and 3, my lord. PW 2 and 3 are vital witnesses for me, my lord, to substantiate my case, my lord. If I am failed, my lord, to place my cases, my lord, I will be prejudiced, my lord.
We will see the matter. We will pass the order.
My lord. Highly available.
At number 12.
May it please, Your Lordship. Your Lordship, I am the defendant in this case. I have challenged the impugned order dated 19/9/2024, wherein a leave for filing a counterclaim has been rejected by the learned civil judge. I'd like to take Your Lordship to page number 57. That is the operative part of the impugned order.
You tell me, is there any limitation for filing counterclaim?
There is a limitation
Yes.
But under
What is the
exceptional,
period?
till the filing of the WS,
Hmm.
we have to file a counterclaim along with the WS.
Hmm.
Otherwise, under exceptional circumstances, that can be allowed. Beyond the filing of WS also.
Where it is written under exceptional
There are certain
circumstances?
judgments, Your Lordship. And another thing which is
You
important.
produce that judgment?
Yes. Lordship, in Mohit Lal Roy versus Shashir Kumar Roy at para 7, I'll read para 7.
But there is a judgment of Supreme Court.
Recently, there is a judgment of Supreme Court where the Supreme Court has said that up to maximum till the commencement of the trial. Till the commencement of the trial, it can be allowed under exceptional circumstances. So, may I read this, Your Lordship? In Ramesh Chandra Adravatiya, para 7, the suit proceeded ex parte against the defendant after several adjournments being granted to him for filing written statement. An application filed for setting aside the order of ex parte proceeding was also rejected by the trial court. A revision brought there against has also failed. At that stage, the defendant filed WS and counterclaim with a prayer for taking.
Which judgment you are referring to?
This one, Your Lordship, 2014-0 Supreme Law 554.
No. It's a judgment of Supreme Court 2020 to SCC 394.
This Suresh Kalra, Ashok Kalra. Your Lordship is referring to
yes.
That, I think. But under exceptional circumstances,
where it is mentioned.
One new judgment is there, Your Lordship, by the passed by the Supreme Court. But I have only one copy. That is the problem.
That's all right. What is the exceptional circumstance in your case?
Your Lordship will see the accrual of cause of action. That is important. So in this case,
when cause of action
arises. So cause of action has arose in this present case at the time of cross-examination of the PW1, which took place on 24/06/2024. I have also annexed that portion.
No.
Because
while filing the written statement, you have controverted that paragraph of the.
No. That what happened
in paragraph number 11.
Paragraph 11. We have
of your
stated
WS.
Yes. But before that, I'd like to take your Lordship to page 29. That is the plaint. Page 29.
Yes. In is 33, you have mentioned cause of action arose on when? 17/7/2020.
Where your Lordship? Page
in the plaint.
In the plaint.
Yes.
No,
Page number
plaint
33.
I'm taking to the taking your Lordship to the operative portion, page 29, para 20. Para 20, the plaintiff stated there that after the death of the Pattadar Izzat Ali on 5/1/2016, as your Lordship got it, the plaintiffs have applied for mutation of their names in the suit patta by right of legal heirship before the office of Circle Office Bipuria. But the learned civil just misconstrued this line. They have said that they have only applied for mutation. But on the record of right in Jamabandi, their names had not been mutated till that date. Or on the institution of the suit also, their names were not there.
No, in page number 33, paragraph number 39, it has been clearly mentioned when cause of action arose.
Page number 33.
Yes.
Page number 33. Page number 33.
17,
cause of action.
2020.
Oh, that is what the plaintiff has stated. I am the defendant here. As per the plaintiff, the cause of action arose on 17/7/2020. But I am saying that my cause of action has arose on 24/6/2024.
How?
because your lordship will kindly come to the cross-examination of PW1, which I have annexed here at page 60. May I read your lordship that page? Is a typed copy. Lordship will find the date is 24/6/2024 when the
Page number, your
page number 60. 60.
Yeah.
The exhibit 5 is the Jamabandi, which was procured by us on 28/12/2022. That is after a period of 2 years from the institution of suit. The plaintiff had exhibited this copy of Jamabandi. We filed the title suit on 15/9/2020. The exhibit 5 was procured 2 years after filing of the title suit. We did not take permission from the court while submitting the said document. Our name was mutated in 3 number patta in the year 2021. The suit, your lordship will find, was filed only on 15/9/2020. While mutating our names in the suit land before the circle officer, we have never informed the circle officer about the pendency of the title suit in regard to the said land before the learned civil judge, not Lakhimpur. It is not true that we have illegally mutated our names as pattadar in the patta of the suit land. While mutating our land in the suit land, we never served a notice on the defendant. Therefore, first they instituted the suit against me on
So,
15/9/2020.
can we take this date as the right to sue accused?
Yes, your lordship, because your lordship will see when the title suit was filed on 15/9/2020, that on that particular date I had no claim against the plaintiff. The defendants did not have any claim.
Oh, you have mentioned in your WS.
No, in the WS, what I have mentioned is
In
at para
paragraph
11,
number
yes.
11, you have denied it.
I have denied that I have never executed the sale deed in the name of the predecessor of the plaintiff, your lordship. That is one Ijjat Ali, not the current plaintiffs. The current plaintiff's name, your lordship will find opposite parties.
You
Yes.
see, in this judgment, Ashok Kumar Kalra versus
Ashok Kumar
Surendra
Kalra, yes,
Agnihotri.
yes.
Here Supreme Court has stated that
Hmm.
we are of the considered opinion that the defendant cannot be permitted to file counterclaim after the issues are framed
After issues are framed.
and after the suit has proceeded
Substantially. But another thing, in this judgment, Mahesh Govindji Trivedi versus Bakul Maganlal, that has been passed by the Supreme Court on 2023-11 SCC 516.
What is the strength of the bench?
The strength of the bench is 2 judges. Here also this.
Earlier one was 3 judges.
Yes, the same judgment has been quoted here. I'd like to read that. In Ashok Kumar Kalra, the 3-judge bench of this court essentially considered the question on reference as to whether it is mandatory for a counterclaim of the defendant to be filed along with the written statement. While answering this question, this court underscored the basic principles that procedural law, this is important, your lordship, should not be construed in such a way that it would leave the court helpless, and that a wide discretion had been given to the civil court regarding a procedural element of suit. So wide discretion has been given. Having said so, this court observed that a counterclaim is designed to avoid multiplicity of proceedings. That time limit for filing a counterclaim is not explicitly provided for, but there is a limitation as to the accrual of cause of action. This is what is important in my case. That the accrual of cause of action in this case occurred on 24/6/2020.
No, that cannot be. That cannot be.
Because on the date of institution, I did not have any claim towards the plaintiff. Because in the Jamabandi also, if I would like to take your lordship, the
Because
Jamabandi.
in your WS, you have
No,
already
that is.
mentioned.
Yes, that I have clarified, your lordship. That paragraph 11, as regards para number 20, it is submitted that application for mutation of land is illegal in view of the fact that the sale deed was not executed by the father of the defendants, not the current plaintiff. The father of the defendants is Ijjat Ali. And we have stated that that sale deed, white sale deed, we have not executed any sale deed towards Ijjat Ali. And so if any mutation is there in the name of Ijjat Ali, that is illegal. So that has been misconstrued by the learned civil code below. And if I would like to take your lordship to the Jamabandi also, which is at page 42. Page 42 towards the last column, remarks. Now, firstly, the name of Patta that your lordship will find. Sri Asmad Ali, son of Mia Hussain, Sri Bahadur Nevar, then Sri Ijjat Ali, son of Junaid, Khatemon Nisa. So, in this list, your lordship will not find the name of the current opposite party, that is the plaintiffs. Your lordship will not find in this list the name of Rajab Ali, Yaqub Ali, Ajab Ali, Mokob Ali. These names have only crept up subsequently during the pendency of suit. The name of Pattadars, nowhere your lordship will find the names of the current plaintiffs opposite parties. Only their father's name is there, that is Ijjat Ali. So it is a clear case where your lordship can interfere. And my leave should be granted in this view of the matter. Because they have admitted
This,
also.
decision of the Supreme Court has to be ignored.
No, it has to. The Supreme Court, this Kalra case, Supreme Court has clearly said that this counterclaim has been designed to avoid multiplicity of proceeding and time
No,
limit
that's all
for.
right, but it has given a timeline.
Yes, it has given a timeline, but under exceptional circumstance, like for filing a counterclaim, it is not explicitly provided. The time of limitation has not been explicitly provided, and it can be extended in exceptional circumstances, particularly when there is accrual of cause of action at a later point of time. Because on the date of filing of the institution of the suit, we are not knowing that these names of the opposite parties were there. It was subsequently filed in the.
No, you have clearly mentioned it in your WS.
No. That is only in regard to Attar Ali, not Attar Ali. That is only in regard to Ijjat Ali. That is the father.
While filing the written statement, it cannot be said that you have no document with you.
No. I did not have any document. The document was only in the
without
name.
any document, you have prepared the written statement and file it.
No. They have stated that they have applied for mutation. Ijjat Ali's successors have applied for mutation after the date of Ijjat Ali.
What
We
is
have
stated in the 2023 judgment?
that till the commencement of the trial, the counterclaim can be entertained. But the thing which is important is the accrual of cause of action. So under those circumstances, the power can be extended.
What is the judgment? We will see it. We will pass the order. Okay.
Obliged.
Number 13.
May I please, your lordship? The petitioner is the plaintiff, your lordship. The petitioner filed an amendment application and which was allowed, lordship, by order dated 10/11/2023, your lordship. Thereafter, the respondent, your lordship, filed a review application along with a delay condonation petition, your lordship. And that delay condonation petition was allowed. That page 50, your lordship. Kindly see the in order, your lordship. Operative portion, lordship, page 55, your lordship. Page 55, lordship. May I read, your lordship?
Yes.
peruse the case record, the petitioners have filed the instant petition to condone the delay in filing the review petition. As the petitioners sought to review the order dated 10/11/2023, the petition ought to have been filed within 9/12/2023, but the petition was filed on 19/12/2023. The delay for filing the petition was on account of illness of one of the petitioner's wife and the delay in receiving the certified copies of the order dated 10/11/2023 on 18/12/2023 and on 9/12/2023 and 10/12/2023 being court holiday. I have perused the medical documents submitted by the petitioners. This is the observation made by the trial court, Your Lordship. Now, Lordship, kindly see the delay condonation application, Your Lordship, page 33.
Yes.
Page 33, Lordship. Paragraph 2, Your Lordship. That on 10/11/2023, Honorable Court was pleased to pass the order in Miss J. Case number says the defendants OP are the brothers and the entire case matter is being looked after and inquired by the OP defendant Sri Usit Bora. That both the defendants OP did not turn up to inquire about the order dated 10/11/2023 and as such in the third week of November 2023, a message was sent about the order of allowing the amendment, but the OP Sri Usit Bora came to Chamber of Advocate on 11/12/2023. That order was passed, inter-party order was passed, Lordship. And their ground is that they did not know about the order and they came to know in the third week of November 2023. But they approached their advocate after about 1 month, 11/12/2023, and informed that his wife is undergoing treatment as she became unconscious suddenly. He is to remain busy in looking after the minors as he got 2 minors. One is studying in class 5 and another aged about 6 years. And hence he could not contact the advocate on account of illness of his wife. The medical document of his illness of his wife is being filed herewith. The defendant OP has been contesting the suit sincerely since the year 2013. Now, Lordship, kindly see paragraph 4. That the review petition is to be filed within 1 month of the date of the order dated 10/11/2023. That is within 9/12/2023. But on 9 December 2023 is the second Saturday and 10 December is the Sunday. And hence the petition is to be filed within 11 December. But the review petition is filed on 19/12/2023. It is not that reopening they filed the application for review and the condonation. After reopening, after 9 days, they filed. And Your Lordship, next, then there is delay of 8 days in filing the review petition and the delay is unintentional. The certified copy was applied on 12/12/2023 and the same was furnished on 18/12/2023. Your Lordship, the certified copy of the order dated, impugned order, that was also applied after expiry of the limitation period. But learned trial court, Your Lordship, wrongly observed and wrongly find that 8 days also will be exempted, Your Lordship. And the holidays, Your Lordship, 10 and holidays, Lordship, being 9/12/2023 and 10/12/2023. That ought not to have been counted also, Lordship. And admittedly, from the application, there is 9 days delay. But the application was filed only for 8 days delay. And there is no verification and supporting affidavit as per mandatory provisions of order 6 Rule 15, Your Lordship. And as per Civil Court rules,
So
Your Lordship.
basically, you are aggrieved by the order dated 10/11/2023, by which the learned trial court has allowed the amendment petition.
Yes, in my favor. In my favor, amendment was allowed in favor of the petitioners, and the defendant filed review application for review that order, Your Lordship. Defendant herein respondent, Your Lordship. And the amendment order was passed after hearing the respondent also, Lordship. They did not file their affidavit objection, Your Lordship, but they verbally objected, they verbally argued, which is reflected in the order, Your Lordship. The amendment,
Please go at this.
Lordship.
Part Sir Earson, learned counsel for the this petition under Article 227. The Constitution. Petitioner has right for setting aside and endorsing the order dated 12/11/2024, passed by the learned civil judge Seniority in Miss Appeal case number 1 of 2024. Is to be noted here that by the order dated 12/11/2024, the learned civil judge Seniority had dismissed the appeal and affirmed the order. Impugn order dated 4/5/2024, passed in DISE case number 145 of 2023, arising out of a petition bearing number 1366 of 2023 in case number 08 of 2013, passed by the learned civil judge junior division number 1. Chief Sagar. There is the petition and the documents plus record, and also there is the impugn order dated 12/11/2024, passed by the learned civil judge senior division Chief Sagar. Then also there is the order dated 4/5/2024, passed by the learned civil judge junior division number 1. That notice be issued to the respondent, returnable and forwards, the be taken by the third post to AD and also by the person. Interim period of the petitioner will be considered on evidence of the other side of facts that leaves the matter after 4 weeks.
Item number 14.
Wait, please, Your Lordship. Lordship, may I take you, Lordship, the order that is on page 39, Lordship, in this case, Lordship. I'm aggrieved by this order because, Lordship, one chance may be given to this petitioner, Lordship, to file written statement against the counterclaim of the defendant, Lordship. I'm the plaintiff of the title suit, Lordship. On receipt of the summon, Lordship, they have appeared, defendant has appeared, Lordship. Within time, they could not file the written statement, Lordship. Thereafter, they approached before this Honorable High Court, Lordship. Honorable High Court granted them, Lordship, extending the time that reflected on page 33, Lordship, to the defendant, Lordship. Now, defendant, Lordship, failed to file the written statement counter against the counterclaim, Lordship, because of wrong entry in my diary, Lordship. That is the only fault on my part, Lordship. Even in the order, Lordship, you will find the order passed on 4/11/2024, but the next day for document, Lordship, it is say 3/3/24, Lordship. Only one date, Lordship, I failed to, Lordship, I sought, Lordship, adjournment, Lordship, filing time. That written statement, Lordship. That
Have
was,
you enclosed that written statement with this petition?
their written statement I have not enclosed.
Is it ready?
We can file, Lordship. It was, we can file, Lordship, within, if Lordship granted time, Lordship, we can file, Lordship.
You pay some cost.
Yes. Yes, sir.
Hardness of this already learned counsel for the in this petition, Article 27 of the Constitution. They are reviewing Section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 4/11/2024 passed by the learned civil judge Seniority and coming from entitled suit number 2/2023. Is to be noted here that by order dated 4/11/2024, the learned trial court has dismissed the petition filed by the petitioner to file written statement against the written statement counterclaim filed by the defendant number 124. Defendant stroke respondent number 124. Is to so to the learned counsel for the petition comes that
Page 10, ground E, Lordship.
is
10, Lordship, ground E, Lordship.
the so to the learned counsel for the petition comes that due to oversight of the date mentioned in his diary. No, due to oversight of the date of hearing in his diary, the written statement could not be filed before the learned trial court, and that only one chance may be given to, only a chance may be given to the petitioner to file the written statement against the counterclaim filed by the defendant number 124. Having heard the submission of learned counsel for the petition, I have carefully gone to the petition and the specific record, and also perused the impugn order dated 4/11/2024. It appears that the learned trial court has fixed the next step for documents, as the plaintiff have neither filed a written statement against the counterclaim nor sought time to do so, which shows a lack of inclination on the part of the plaintiff side to file a written statement against them. However, taking note of the submission of Mr. Sodori, learned counsel for the petition, this court is inclined to allow the petition. It is provided that allow this petition by setting aside the impugn order dated 4/11/2024. However, subject to payment of cost of rupees 5,000.
So can it be 2,000 loss?
No.
Lordship, can it be 2,000 loss?
On that day, there was no payer on your behalf.
That verbal payer was there, Lordship. I have come with the petition, but that was not accepted, Lordship. Page 32, Lordship. That
Further provided that the learned trial court shall accept the written statement filed by the petitioner against the counterclaim filed by the defendant stroke respondent number 1 and proceed. Then thereafter proceed to hear the matter in accordance with law in terms of above this CRPI is disposal.
Highly obliged. Highly obliged.
Item number 15.
May it please this manner. My lord, I have assailed the order dated 22/10/2024, whereby my lord, the prayer for amendment of the plaint was allowed. Now, if my lord goes to the amendment application, my lord, there is absolutely no, my lord, whisper about why the amendment application could not be filed at an earlier date. In fact, they have admitted that it was within their knowledge at the time of filing institution of the suit. In spite of that, my lord, after 6 years have gone by, suit was instituted in the year 2018.
And what is the suit is pending?
PWs, my lord. 13/2/2023, the suit was fixed for PWs.
It's the equal, there is the recent judgment. of
LIC
Supreme Court
versus
that,
Sanjeev Builders, my lord. I'm aware of
all
that.
amendments would be allowed.
Allowed, my lord.
This is necessary for determination
My
of
lord.
real
But-
controversy.
I have come with another judgment, my lord. Recent judgment of the Supreme Court, my lord. 2024, 2 SCC, 3 SCC 705, my lord. Para 8 is necessary. I agree, my lord. All amendments should be allowed, my lord. But
Then-
there has to be an explanation, my lord. 2024, 3 SCC, my lord. Para 8.
Yes.
Proviso to Order 6, Rule 17 CPC provides that no application for amendment shall be allowed after the trial has commenced unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. In the case in hand, this is not even the pleaded case of respondent number 1 and 2 before the trial court. In the application for amendment, the due diligence was there at the time of filing of the suit in not seeking relief prayed for by way of amendment. All that was pleaded, what was pleaded was oversight. The same cannot be accepted as a ground to allow any amendment in the pleadings at a fake end of trial, especially when admittedly the facts were within the knowledge of respondent number 1 and 2. Here also, my lord, they have sought that, my lord, the defendant number 1 is not the legal.
Whether the earlier decision was taken note of in this judgment,
No, my lord. It is not discussed.
not discussed.
Not discussed.
Then can this decision be read as a precedent?
My lord, the earlier judgment, my lord, at Para 70 has laid down certain guidelines, my lord. That such and such, if these are complied with, my lord, amendment should be allowed for just and proper adjudication of the case. Well, here is the case, my lord, where they have failed to give any explanation why they could not bring about the amendment application because it was within their knowledge.
No, if that was not in the earlier judgment, this judgment cannot be taken into account.
This is the recent judgment.
Maybe.
Plus, there are
So
other
far, the doctrine or precedent is concerned, which judgment will prevail, the earlier or the later?
earlier one.
Then-
But here, my lord, facts are a little different. That's why, my lord. And secondly, my lord, they have sought that the marriage of the defendant number 1 should be declared as void. And that application has to be filed before the district court, my lord. Because section 17 of the Hindu Marriage Act, my lord, specifically states. Can I just read out, my lord?
You raised the issue before the trial court. That court has no jurisdiction.
I have
to
raised, my
deal
lord,
with
but
the matter.
trial court has ignored it, that fact. I've already raised.
Where is that order?
Order, my lord, will find at page number 72. Relevant portion is at page number 82.
Page number 82.
82. Discussions, decisions, and reasons here. My lord has got it. Now, having heard argument of both sides and on perusing the case record, including the case record of the main suit, it is found that the main suit is pending at the stage of issues and documents in SBPH when the instant petition application was filed, that is, trial is yet to commence. But, my lord, as per order dated 13/2/23, PW was fixed, my lord. Again, it revert back, my lord.
Pardon?
As per order dated 13/2/2023, my lord, it was fixed for PWs, although it is stated that, my lord, it is as a stage of SBPH. It is found that the additional paragraph sought to be inserted by the petitioner plaintiffs, together with the additional prayers in the plaint, is more or less relating to the alleged second marriage of the deceased husband of the petitioner, plaintiff number 1 with the OP, defendant number 1, and the defendant number 2 and 3 born out of such marriage, and their legal entitlement in respect of the properties left by the deceased husband of the petitioner, plaintiff number 1. Now, one law point that has been raised by the learned counsel for the OPs, defendants,
Page number?
page number 83, man.
Yes.
Now, one law point has been raised by learned counsel for the OP's defendants is to the effect that the instant application is more or less contains the same subject matter relating to marital status of the OP defendant number one, that the deceased husband of the petitioner plaintiff number one and a determination of such issue or subject matter is beyond the jurisdiction of this court, this final. Rather has to be decided by the Court of Honorable District Judge Kokrajhar. On the aforesaid aspect, this court has gone through the pleadings of the parties and found that whereas on one hand, the petitioner plaintiffs are claiming that the deceased husband petitioner plaintiff number one converted into Christianity and got married with the petitioner plaintiff number one. But on the other hand, it is the claim of the defendants that the deceased husband of the plaintiff petitioner was actually a Hindu and professed Hindu religion till his death. Now, the aforesaid aspects are matters not to be decided or adjudicated at this stage, but the matters to be determined and decided at the finality of the instant suit in hand, and thus further discussion on this aspect is hereby.
Mr. Iqbal, I have not challenged this order.
My lord,
You have not challenged this order.
I have challenged this order, my lord. This is the amendment application order. 22/10/2020.
No, this observation has not been challenged by you
My lord,
regarding jurisdiction.
jurisdiction, my lord, I have taken the point that, my lord, the district court has a jurisdiction.
No, that's all right.
Civil court has no power, my lord. If my lord allows me to again, my lord, take up that issue in the trial court, my lord, because this is a vital aspect, my lord. The civil court has no jurisdiction as per section 17 of the Hindu Marriage Act.
Lord Mr. Iqbal, learned counsel for the petitioner. This petition under Article 257 graduate Section 151 of the Code of Civil Procedure. The petitioner has challenged the aggravations or other to the order dated 28/11/2024. Passed by the learned civil judge Seniority with an act to the Niche case number 9 of 2023 arising out of title number 3 of whereby the learned trial court has allowed the plaintiff, the respondent hearing, to file their amended claim. Mr. Iqbal, learned counsel for the petitioner, submits that whether you have filed a petition before that court
My lord, I have
raising
filed
this
a-
issue.
I have filed the objection, my lord, that my lord will find at page number page number 58. Specifically, my lord, paragraph number 7. Paragraph 7 is at page 61, my lord.
At the time of hearing on the petition filed by the respondent hearing for amendment of the claim, the present petitioner has filed a written objection. And at paragraph number 7 of the said written objection, the petitioner has taken a stand that The learned trial court has no jurisdiction to deal with the matter who is supposed to have been filed before the honorable before the learned district judge Kukrajar as per provision of section 11 of the Hindu Marriage Act, as the matter relates to marriage between the petitioner and the respondent herein. But the learned trial court that ignored the same. That since the having heard the submission of learned counsel for the petitioner, I have carefully gone through the petition and the documents as record, and also perused the impugned order dated 22/10/2024, and also the written objection which is filed in the petition as annexure, which is enclosed with the petition as annexure number 4 at page number 58 of the petition. Taking note of the submission of Mr. Iqbal, learned counsel for the petitioner, and also considering the facts and circumstances which the record, this court is inclined to dispose of this petition by directing the petitioner to approach the learned trial court again by filing an appropriate petition raising the issue of jurisdiction. And in the event of filing such an application, the learned trial court shall consider the same with the terms of request.
Issue of jurisdiction and any other point as per law, madam.
No, issue of jurisdiction. That is the vital issue.
Madam. Section 11 and section 17, madam, Hindu marriage.
17 has not been mentioned in the
That application is
11, in respect of section 11 of it. Will you resume after 5 minutes?
17. May I please, Your Lordship? Your Lordship, this matter has been fixed for admission hearing, Your Lordship. Your Lordship, buildings have been completed otherwise, Your Lordship. On the last occasion, on the insistence of the respondents, Your Lordship, private respondents, this matter has come up for today. May I just start off comments with you? Your Lordship, before I commence with my argumentation, Your Lordship, in this matter, and the legal arguments which have been divided into many components, if Your Lordship peruses the first order passed by this Honorable Court on 24/8/2021.
Twenty-four?
24/8/2021, Your Lordship.
Yes.
Yes, Your Lordship. If Your Lordship peruses para 8, Your Lordship. May I read, Your Lordship? Your Lordship, ordinarily, we have looked into as to who between the two would be senior. That is, Your Lordship, the private respondents number 6 and 7, for the purpose of an interim order restraining the benefit of provincialization to the language teacher who would be junior to the other on the basis of the dates of their respective appointments. But in the instant case, we have taken note of that the school concerned, that is Borofa Upendranath Brahma MA School, is a school in Boro language, meaning thereby that there may be some preferences for a language teacher of Boro language. The Act of 2017 is silent to that extent as to whether any precedence is to be given to a teacher of the language, which is the medium of the school concern. Again, education is a transferred subject under the 6th schedule to the Constitution of India, and under the law of the 6th schedule, the authorities of the Boroland have a discretion either to adopt the Act of 2017 as it is or not to adopt it, and adopt their own procedure or to adopt it with modification as may be made. It is not known at this stage as to in what manner of the Act of 2017 has been adopted by the BTC authorities and made applicable, as it cannot be said with certainty as to in what manner the Act of 2017 would be applicable to the areas under the BTC, and whether respondent number 6, being a teacher in Boro language, would have any kind of precedence over the other language teachers, we deem it appropriate to provide in the interim that the benefit of provincialization be not given to the respondents number 6, Narad Chandra Brahma, and the respondent number 7, Lohit Chandra Brahma, until further orders. Your Lordship, my only purpose before your Lordship to bring the attention of this Honorable Court is the very fact that on the basis of the date of appointment, on the basis of the date of joining of all the parties involved, the Honorable single judge was of the opinion that since at the very instance when the case was taken up for motion, the respondent number 6 and 7's appointment were not at all being discernible. So on that particular account, the interim had been passed, saying the benefit of provincialization. It has always been the case of the private respondents, on the virtue of being senior to the petitioner, their cases have been provincialized. And it is also the case of the BTC authorities, who is also a state respondent herein, that because of the respondent number 6 being overaged, then the petitioner's case had to be given, not considered, and the respondent number 6 case was given into consideration. Your Lordship, the Honorable Single Judge was correct in its opinion that because of the date of joining,
we are presently not deciding whether this order dated 24/8/2021 is correct or incorrect.
Yes, Your Lordship.
You argue your case.
Yes, Your Lordship. Then I'm just pointing out the only one aspect before this Honorable Court, that the whole stand taken by the state respondents and by the private respondents, that on the basis of seniority, their cases would have to have been provincialized, is correct in the view of the law. But whereas the Act of 2017 is very much in its own purpose, is not at all, their submissions are not in accordance with the Act, Your Lordship. Because if Your Lordship peruses the whole Act, Your Lordship, there is no criteria for seniority. Second of all, the only one requirement which has to be considered by the state respondents was to consider the DISE data, which is the record of the schools, which they have not done it. And the state respondents, they have only taken the view that the school managing committee of that particular school's recommendation was considered. That is also completely illegal and irregular. So I'm just now proceeding with my case, Your Lordship. Your Lordship, if Your Lordship peruses Annexure A, Your Lordship, the appointment of the petitioner at page number 21, Your Lordship. Your Lordship, the petitioner was appointed by the managing committee of Bodofa Upendranath Brahma School, and he was appointed as an assistant teacher on the basis of honorary. His post is purely temporary and may be terminated without any further information, Your Lordship. Thereafter, Your Lordship, after the appointment of the petitioner, if Your Lordship peruses Annexure B, had joined on 1/1/1993 at 10:15 a.m. If Your Lordship peruses Annexure B, page number 22 is his joining letter, Your Lordship. Yes, Your Lordship. Now, if Your Lordship peruses Annexure C, is the inspection report prepared by the Block Elementary Education Officer, which is at Annexure C, page number 24, Your Lordship, wherein the name of the petitioner is also being reflected as the second senior most teacher serving in the said Bodofa Upendranath Brahma ME School, Your Lordship. If Your Lordship peruses page number 25, the name of the petitioner is reflected at serial number 2, down below staff position, Your Lordship. Yes, Your Lordship. Now, if your lordship peruses the very provincialization, your lordship, which is an annexure F, page number 31. Serial number 29, District Baksa, Bodo, Block Elementary Education Office, Tihu, Bodofa Upendranath Brahma Zaripar. Your lordship, the respondent number 7's name appears first, Lohit Chandra Brahma. Then at serial number 30, respondent number 6 names appear, your lordship.
Serial number?
Serial number 30, your lordship. If your lordship peruses page number 31.
Yes.
Yes, your lordship.
Respondent number, serial number?
29 is respondent number 7 and serial number 30 is respondent number 6, your lordship.
Respondent number 29.
The serial number 29 is respondent number 7 and serial number 30 is respondent number 6, Narad Chandra Brahma. Yes, your lordship. Now, your lordship, if your lordship peruses annexure G, District Scrutiny Committee's report, which is of the year 2017 at page number 34. Now, this particular report has to be taken into consideration by this honorable court, your lordship. If your lordship peruses the type copy, which starts at page number 32, your lordship. If your lordship peruses page number 33, as per the District Scrutiny Committee's report after the coming of the 2017 Act, your lordship, this District Scrutiny Committee's report was prepared in the year 2017, your lordship. The name of the petitioner, if your lordship peruses, Dharani Chandra Brahma, was still at the second senior most teacher of the said school, and the subjects which has been assigned to him to be taught by him was English and social science, your lordship. Now, that aspect of the matter would come into very clear understanding, your lordship, if your lordship peruses the affidavit in oppositions filed by the respondent number 6 and 7, your lordship, the DISE data. English and social science, your lordship. That has always been my case, that I have taught English and social science, your lordship, in my writ petition, your lordship. And your lordship very well peruses annexure Z, representations made to the Director Elementary Education, your lordship, because of the non-provincialization of the cases of the petitioner, your lordship.
Page number?
Page number 40, your lordship.
Yes.
Yes, your lordship. It has clearly been reflected by the petitioner, your lordship, that since he was discharging his duties as an English and social science, actually his case should have been considered for provincialization. But his case was not considered and the respondents were considered for provincialization. I will just take your lordship in a while that how the illegalities have been committed by both the respondents 6 and 7 in order to deprive the petitioner from provincialization, your lordship. This is the whole case in the writ petition, your lordship.
Yes.
Yes, your lordship. I'll just take your lordship to any of the affidavit in opposition filed by the respondents, your lordship. I'll just take your lordship to the affidavit in opposition preferred.
In your representation, where you have mentioned that you were teaching English also.
Yes, your lordship.
You have simply mentioned that you were social science.
Yes, your lordship. That aspect of the matter would come up from the DISE data. That is why I'm taking your lordship to the DISE data, which have been produced by the respondents, your lordship.
Why you have not mentioned it in your representation?
Yes, your lordship. Yes, Your Lordship. Yes, Your Lordship. However, that fact of the matter is still being Your Lordship, it has still been substantiated by the DISE data which the private respondents have furnished before this honorable court, Your Lordship. Now, Your Lordship, DISE data is District Information System for Education. The very purpose of DISE data is that, Your Lordship, that it reflects the existence of the school. Number two, Your Lordship, it also reflects the existence of the serving teachers in those schools. Number three, it also reflects the service career of those teachers who have been teaching in that school. And furthermore, Your Lordship, it also reflects the subjects taught by the petitioner and the private respondents, Your Lordship. Even though there has been an omission in the representation, but at the end, Your Lordship, the DISE data reflect the same, Your Lordship, what the petitioner case has all been about, Your Lordship.
In which the DISE data it has been mentioned?
Yes, Your Lordship. I'll just take Your Lordship
Page
to
number?
Yes, I'll just take Your Lordship to the affidavit in opposition preferred by the respondent number 7, because both the respondents have filed the same contents of the affidavit in opposition wherein DISE data have been reflected here. Respondent 7 is the headmaster, Your Lordship, and since he is the custodian of the school, he has also produced the same DISE data, whereas respondent number 6 has also produced the same DISE data. Yes, Your Lordship. I'll just take Your Lordship to page number 69, Your Lordship, 2017-18. After the 2017 Act came into existence, Your Lordship.
Page number 69.
Yes, Your Lordship. Lordship, there has been one issue that the pages that have been marked by the private respondent seems does not have to relate with the affidavit, Your Lordship. I'll just take Your Lordship. Your Lordship may very well peruse page number 111.
Yes.
Yes, Your Lordship. Lohit Chandra Brahma, Your Lordship. This is the DISE data for the year 2017-18. If Your Lordship peruses at the top right corner, year 2017-18. Yes, Your Lordship. Now Your Lordship will very well peruse main subject taught 1. Yes, Your Lordship. 31 is the code, Your Lordship. The subject taught being borrow, and main subject taught number 2, which is the secondary subject, is social science or social studies. Now, Your Lordship, if Your Lordship...
Who is part of the page?
Yes, Your Lordship. If Your Lordship comes to the column number 12, perhaps Your Lordship, main subject taught 1 and main subject taught 2. The first column.
Number 12.
The row number 12, Your Lordship. Row number 12.
Yes, main subject taught.
Yes, Your Lordship. Main subject taught 1 and main subject taught 2, Your Lordship.
Social studies.
Yes, Your Lordship. The private respondent number 7, who is the headmaster, Lohit Chandra Brahma, Your Lordship. His main subject, which is reflected as number 1, is borrow. And his secondary subject is social studies. Now, Your Lordship, the petitioner, Dharani Chandra Brahma, Your Lordship, his main subject number 1 is social studies, and 46 is the code, Your Lordship, which has been assigned for English, Your Lordship. In the previous DISE data, Your Lordship, against the subjects, there has also been an assignment of, Your Lordship, codes, particular codes, which also defines the subjects, Your Lordship. And respondent number 6, Your Lordship, Narad Chandra Brahma,
His main subject is also number 1 is Boro, and his main secondary subject is mathematics, Your Lordship. Yes, Your Lordship. Now, if Your Lordship peruses page number 112, the same situation has been reflected. If Your Lordship peruses main subject taught 1 and main subject taught 2. And this is the DISE data for the year 2018 and 19.
Where it is mentioned?
Yes, Your Lordship. If Your Lordship peruses row number 13, main subject taught, and row number 14, main subject taught 2, here only, Your Lordship, the codes have been assigned, 31 and 8. Then, if Your Lordship peruses Dharani Chandra Brahma for 8 and 46, 31 and 3. Now, I'll just address the issue. If Your Lordship peruses any of the DISE data, Your Lordship, prior to 2017, Your Lordship, if Your Lordship peruses the DISE data for the year 2012-13, the codes have been assigned to the subject. Annexure 15, Your Lordship, page 106.
Okay, that's all right. Thereafter?
Yes, Your Lordship. Now, here in this instant case also, Your Lordship, the petitioner has already been teaching social studies and English, whereas the respondent number 6 has taught Boro language and mathematics, Your Lordship, and whereas the respondent number 7 has also taught Boro language and mathematics, Your Lordship.
Respondent number 7, Bodo and?
Your Lordship, Boro language and social science, and respondent number 6, Boro language and mathematics, Your Lordship. So there has been a usurpation of the post, Your Lordship. Now, after that, Your Lordship, the respondents, they have not placed the records of the petitioner, Your Lordship, as far as my information is concerned, the subsequent DISE data, Your Lordship, only till 2000, Your Lordship, 18-19, and furthermore, the DISE data which also they have furnished is for the year 2021, Your Lordship. The DISE data which they have also furnished, Your Lordship, in this instant matter. If Your Lordship peruses the affidavit in opposition filed on 31/8/2024, respondent number 6, DISE data being furnished for the year 2020-21, page number 113 to 137.
Oh, that's all right. Thereafter?
Yes, Your Lordship. Now, thereafter, Your Lordship, the respondents had, without any information to the petitioner, had degraded his ranking from second senior most to the fourth senior most in the table, Your Lordship.
Where is that table?
Yes, Your Lordship. It is in the very aspect which the respondent number 7 has preferred in the affidavit in opposition. It is their case that since the respondent number 7 being the headmaster and being a part of the school managing committee, they have held a school managing committee's meeting wherein the petitioner was never made a party to that meeting. On that particular meeting, it was decided that the respondent number 6 and 7, they deserve to be provincialized. So they need to be provincialized with the consent of all the members of the school managing committee. The petitioner being irregular and also not attentive to his duties, his services should not be provincialized.
And
Where is the
furthermore,
resolution?
yes, I'll just take your lordship. To the very affidavit in opposition filed by this private respondent number 7, annexure 23. I'll just take your lordship.
Page number.
Page number, your lordship, if your lordship peruses page number 114 of the affidavit in opposition filed by the respondent number 7. That starts, your lordship. I'll just take your lordship to the very page 116, your lordship. I'll just read the second paragraph, if your lordship allows, your lordship. After the purpose of the meeting, the president asks the people to speak something regarding the selection of teachers for provincialization of services. One of the speakers, Srimati Anita Brahma, expressed her opinion that I have nothing to say regarding science teacher. But Lohit Chandra Brahma, who is doing all kind of management of the school as headmaster, so his service should be provincialized. Dhorni Chandra Brahma is not doing his duty properly, who gives him trouble in smooth running of the school. On the other hand, Robin Brahma expressed his opinion that Narat Chandra Brahma, assistant teacher of the school, should be given second preference as he has been doing his duties regularly and punctually. Moreover, he is son of landowner who gifted his 5 bighas of land in the name Borofa Upendranath Brahma ME School, Zaripar. Your Lordship, that is the whole reasoning, Your Lordship. And if Your Lordship peruses the next page, the President thanked to both the speakers whose valuable suggestion was appreciable. According to him, Lohit Chandra Brahma should be given first preference and second preference should be given to Narat Chandra Brahma. He also reiterated that Dhorni Chandra Brahma did not want service, so he did not attend the school regularly. At the end, the President asked the audience whether resolution should be taken in favor of Lohit Brahma and Narat Chandra Brahma, where they acceptable, and if so, support the resolutions by clapping. The following resolutions were accepted after supported by clapping, Your Lordship. So, Your Lordship, in this school managing committee's meeting, Your Lordship, the petitioner was not made a privy to that whole aspect, Your Lordship. The petitioner should have been made, Your Lordship. Now, their stand is that, Your Lordship, that since from the day of joining the school, that is day 1, I have been irregular. Your Lordship, I have not been attentive to the school's students, Your Lordship. Then, Your Lordship, my name should not have been reflected till the end of the year 2021 when the whole provincialization process began, Your Lordship. If I was so irregular, unattentive, Your Lordship, my particular job was terminable without any issuance of show cause notice. That was also not being done, Your Lordship. Furthermore, my whole job was, Your Lordship, was temporary, Your Lordship. And if I had committed any breach, Your Lordship, then they would always be at liberty to terminate my services. But they did not do at the end, Your Lordship. Now, the whole aspect of school managing committee's report, Your Lordship, or the meeting was that, Your Lordship, I was not given a show cause even to present my case. So that in itself has been a violation of principles of natural justice. Now, what did the state respondents do on the other hand?
No, whether the state level committee, while considering the case of provincialization,
Yes, Your Lordship.
has relied upon this resolution.
Yes, Your Lordship.
Where it is mentioned?
Yes, the affidavit in opposition preferred by the BTC authorities, Your Lordship.
That is number?
Yes, I'll just take Your Lordship. Yes, Your Lordship. I'll just take Your Lordship to. If Your Lordship peruses page number 183 of the affidavit in opposition filed by Your Lordship, the Director of Education, Boroland Territorial Council, Your Lordship. Para 14, Your Lordship.
183.
Yes, Your Lordship.
Paragraph number 40.
14, Your Lordship. That as regards to the statements made in paragraph number 15 of the writ petition, the answering deponent begs to state that the decision of school managing committee is the final decision. Para 15, Your Lordship, that as regards to the statement made in para 16 of the writ petition, the answering deponent begs to state that the headmaster had prepared and submitted the provincialization of service list for said school as per instructions / decision of the school managing committee.
Is there any provision in the
No, your
main act
lordship.
itself?
No, your lordship. I'll just satisfy your lordship's query. If your lordship peruses the 2017 Act, your lordship,
Yes.
Section 13, your lordship. Your lordship, Section 13 is District Scrutiny Committee and State Level Scrutiny Committee. May I just read subsection 1, your lordship? Yes, your lordship. Now, if your lordship peruses subsection 6, your lordship. One, two, two. One, two.
Yes. 13.
Yes, your lordship. Your lordship, if your lordship peruses subsection 5, the District Scrutiny Committee for Elementary Education shall be constituted with the following members, namely so and so, your lordship. If your lordship peruses subsection 6, your lordship, the District Scrutiny Committee shall first scrutinize and prepare a list of all venture educational institutions within the district which are eligible in terms of the provisions of this Act, and shall thereafter proceed to scrutinize and verify the service records of all the serving teachers who are eligible or would become eligible for being considered for provincialization of their services. The district committee shall identify a base school for each category of school and recommend the name or teacher oblique tutor to be associated against each base school, your lordship. Your lordship, subsection 8, your lordship. The district scrutiny committee shall have the powers to inspect physical existence of school and to inspect all documents and records produced before it and call for such further records and documents as may be required for the purpose of causing verification and scrutiny and examine witnesses for the purpose, if considered necessary, and while doing so, it shall have the powers of a civil court for the purpose of compelling attendance of persons and production of documents, your lordship. Now, if your lordship peruses subsection 11, the state level scrutiny committee shall have to cause physical verification of all institutions and will also inspect all documents and records produced before it and call for such other records and documents as may be required for the purpose of causing verification. Subsection 12, when there arises difference in between the recommendation of the District Scrutiny Committee and the physical verification report caused by the State Level Scrutiny Committee, the matter shall be placed before the State Level Scrutiny Committee, and the decision of the State Level Scrutiny Committee shall be final. Here, Your Lordship, in this instant matter, Your Lordship, the BTC authorities, that is the Director of Bodoland Education Council, Bodoland Territorial Council, Your Lordship, they have only considered the recommendations made by the school managing committee, which is, as per Your Lordship, contrary to the very provisions of the Act. It is the District Scrutiny Committee which has to prepare the list, Your Lordship, scrutinize the existence of the school, scrutinize the services of the teachers who are eligible for provincialization, and it is only them that they would have to further recommend the names of the teachers to the state level scrutiny committee. Here, everything was kept under, Your Lordship, silent, Your Lordship. The petitioner was never informed about any of the processes, Your Lordship. So here, Your Lordship, there has been two aspects of illegality. The District Scrutiny Committee has acted in its illegal and arbitrary manner.
Where is that district level scrutiny committee's recommendation?
Yes, Your Lordship. The Elementary Education Department, they have also filed their affidavit in opposition, but it is of a sort of a cryptic in nature, where I'll just take Your Lordship to the very affidavit in opposition filed by the Elementary Education, by the director, Your Lordship.
Page number.
Yes, Your Lordship. Page number, I'll just take, Your Lordship, to para number 5, page number 42.
It is the affidavit of respondent number 7.
No, Your Lordship. The affidavit filed by the Your Lordship, Elementary Education, Director of Elementary Education, page number 42. Your Lordship, that is the second affidavit which the Elementary Education has filed.
Affidavit in opposition dated 14 December 2022.
Yes, Your Lordship.
Okay.
Your Lordship, page number 42, Your Lordship, there are 5.
That is page number 179
Your
in the
Lordship.
petition. Yes, paragraph number.
5, Your Lordship.
Yes.
Your Lordship, they have also taken a very categorical stand that they have only quoted the very sections of the Act of 2017. They stated that, Your Lordship, since the District Scrutiny Committee did not recommend the name of the petitioner, so, Your Lordship, the decision of the District Scrutiny Committee has to be taken into consideration. Now, the school which is an issue in this case, Your Lordship, falls under the 6th schedule. So here, Your Lordship, the BTC authorities, Your Lordship, affidavit, and also in consonance with the affidavit in opposition filed by the Elementary Education Department, both runs contrary to each other. One of the BTC's authorities' stand is that, Your Lordship, the recommendation of the school managing committees is the final decision. Here, on the other hand, the Elementary Education's stand taken by them is that since the District Scrutiny Committee has not recommended, so the name of the petitioner was not considered. Now, the very issue which has cropped up is that, Your Lordship, the route from which every decision has come up, Your Lordship, was on the basis of the school managing committee. But the Act runs, Your Lordship, contrary, Your Lordship. It is the District Scrutiny Committee which has to scrutinize the services of the records, and they would have to recommend, not the school managing committee. Otherwise, Your Lordship, the school managing committee's decision would run, Your Lordship, very contrary to the whole provision of the Act, Your Lordship. So there is no purpose of the District Scrutiny Committee being in existence, Your Lordship.
So, is there any provision in the Act itself about the role of the district level committee?
Yes, Your Lordship. Section 13 is the Act. It's wherein it has specifically provided the duties and responsibilities. Section 13 of the 2017 Act, Your Lordship.
Yes.
Yes, Your Lordship. So, Your Lordship, there has been a categorical and egregious violation of fundamental rights guaranteed under Article 14, Your Lordship. Therefore, Your Lordship, I have challenged the same. Your Lordship. In the
So
provincialization.
which for the state response?
Lordship, the assistance of Your Lordship PTC authorities is necessary, but however, they are.
Who is for the director? Elementary education? You are. What is your submission? Both recommendation? But the district scrutiny committee has relied upon the recommendation of the school management committee. Whether school management committee has any role? No. So according to you, this order is illegal. Yeah, so who is for respondent number say 6 and 7?
What is 6 and 7, one way of 6 and 7? I'll affidavit.
Yes.
Lordship, respondent of private respondent number 6 is teacher of Bodo language, that means a language teacher. And 7, respondent number 7 is the headmaster. He teaches English as well as social science. And as far as respondent number 6 is 2 years older than the petitioner.
Respondent number 6.
Respondent number 6 is older than petitioner, 2 years older. The date of birth is 65.
Who was appointed first? The petitioner?
Always, all three respondents 6, 7, and as well as the petitioner appointed on the same day and joined on the same day.
The petitioner joined at 10:15 a.m. Your Lordship. The respondent 6 10:25 and respondent 7 10:30 a.m.
On the same day, but the timing is different.
Yes.
Petitioner at 10:15
a.m.
a.m.
And respondent number 6?
Respondent 6 10:25. And respondent 7 is 10:30 a.m. 10 minutes and 15 minutes different. Joining date same, but after being joined in the school, he took leave for 1 month.
Oh.
A petitioner. That is Lordship, in the month of January, join also in the month of January, from 53, page number 53. Lordship, chair one is Lohit Brahma, second Dhanani Brahma, and third
You were referring to
page number 53.
53.
Just join, but the whole month remain absent. Thereafter also several absent. This is para 6 in the affidavit. Page 45, para 6. One on 1993 joined, and from that day, 29/1/2020, 1993, he remained absent. That is 1 month absent. Thereafter, para 6, page 45 of the affidavit of respondent number 7, Louis Brahma.
Yes.
And 46, just before provincialization in February of 2021, 1 month in November and 1 month in December. Page 46, 1 month in November 2020, 1 month in December 2020. That means 2 months. Continually, consecutively 2 months absent.
Absent or he was on leave?
Yeah.
Your Lordship, it is their case, Your Lordship, not my case.
Some are authorized and some are unauthorized. But how? Due to the absence of one teacher for so many days, the school will run.
So
It, is
whether you have
it was
taken
very
any
difficult.
action, no,
Run smoothly.
whether you have taken any step for his unauthorized absence.
And as per
No, you answer my question. Whether you have taken any step upon him, taken any action upon him for
verbal he was warned, but no step, written statement, written notice was given and no action was taken in black and white.
Then?
Just for mentioning it is. And thereupon, the respondent 6 is from the very beginning and to the last, before provincialization, until then, he is a language teacher. All the data, that is 2011 to 2029-20, and thereupon 9-10 and 2020-21 also. In all DISE data, it reflects that number 6, respondent number 6 is the language teacher. And respondent 7 is science teacher, social science teacher. From, as per his petition, from the beginning, from the date of joining, he is doing service as a social science teacher. It is misleading. I am showing that is page 105. From 105 page.
Your Lordship,
Yes, sit down.
yes, sir.
Lordship 104, Lordship 104. 2 means language teacher, and 8 means social science teacher. The 104, Louis Chandra Brahma, Louis Chandra Brahma 2 and 8. That means 2 is language teacher as well as social science teacher. Number 2, Louis Chandra Brahma is petitioner. Petitioner is 2 classes taught and main subject taught 2. That means language teacher. In all cases, language teacher. Naraswanda Brahma, that is respondent number 6, 2 and 2. That is main subject language teacher and subject taught also language teacher as a language teacher. 2011-12, that is 105 page number. Louis Chandra Brahma is the headmaster from the very beginning. Without headmaster, no school can run properly. Louis Chandra Brahma 2 and 8, that is language teacher as well as social science teacher. Number 2, Dharani Chandra Brahma 2 and 2, that is language teacher. Main subject and subject to main subject as well as classes taught. Subject taught is language. Number 3, Naraswanda Brahma, that is respondent number 6, 2 and 2, language teacher. And 106 also, page 106 also, for 12-13, 2-8, language and social studies. And Dharani Chandra Brahma, all subject 1 and 8, 2, language teacher. Naraswanda Brahma also, all subject and 2 means language teacher. Thereafter, 13-14 to last part, that is 2021 to both petitioner as well as the respondent number 7 taught social science. Because rotationally it was entrusted, sometimes petitioner also entrusted for teaching social science, and from the very beginning up to the last part, that is up to before the provincialization, he taught social science, that is headmaster. 2013-14, Louis Chandra Brahma 2 and 8, main subject taught 8 social science. Dharani Chandra Brahma petitioner 29 and 8. He was also entrusted to teach social science.
It's
Naraswanda Brahma
what
3.
is this 29?
What's it?
29.
29. English, Lordship.
English.
English. Next 14-15, it is 108 case number.
So who filed this DISE data?
DISE data, yes.
Who filed this DISE data?
The respondent number 7 as well as 6.
Number 7. Why? Why
All
there
everything.
are so many?
I have not concealed anything. No suppressed. Nothing suppressed. Nothing concealed.
No. Why there is overwriting?
Overwriting means on yearly basis. That was changed in rotation system. That is why, as he is being the headmaster, he altered or erased or override. It may be called for if required. 15-16, Lohit Brahma 2 and 8.
Okay. So you are admitting that he joined
Lordship,
prior to you.
again, again, okay,
No, no, the
file,
petitioner joined prior to the respondent number 6 and 7.
but the petitioner something suppressed and not disclosed properly, because as per the petition, I have been discharging my duty from the very beginning as social science teacher. But as per the records, as per the DISE data, he was absent up to 2013. From 2009 to 2013, he was not authorized to teach social science. Thereafter, both myself, that is myself, respondent number 7, as well as the petitioner, both we taught, sometimes myself and sometimes the petitioner taught social science. I have produced everything, nothing concealed.
But being the headmaster, you have not taken any action upon him for remaining absent such a long period.
So I am headmaster, I am social science teacher. So I may be appointed, and that is why appointed as teacher. And in the list also, I am senior most. I am, as per list also, it is not denied by the petitioner that I am respondent number 1. I am the serial, as per serial number, I am the senior most, that is 1. And somehow his name was entered in only for 10 minutes. 10 minutes earlier he joined, that is why 2. As per the scrutiny report, district scrutiny report, prior to 2017 Act, that was 2011 Act, that was repealed. As per 2011 Act, he was shown as senior number 2. And as per other report, inspection report also, he was shown, as per their claim, shown second senior most. But due to their absence, irregularity, and and other things, because he was the 6 is the
who is for BTC?
donor of the land, son of the donor of the land, and he was else he will retire on 31st July this year. This year 31st he will retire, and he's more than 2 years. He will get the opportunity if this court allow him and direct the education department to provincialize his after his retirement. Or already I have learned from the reliable source that already proposal has been sent to the education department for provincialize other posts also. And as per defined losses.
No, yes. So who is for BTC?
Losses. Supreme Court judgment as well as this court, High Court judgment also there. If same date, joining date is same, then age and other criteria should be considered. That is, I am percentage, my mark is percentage of 36, my 38% in higher secondary. He is 37. I am 2 years older than him. And respondent number 7 graduate, BA. And he is from the very beginning, he is a headmaster. As well, he is teaching social science.
And this respondent number 6?
The 6
when
is
he
from
will be
the very
retiring?
beginning,
No.
language teacher.
When the 6 will be retiring? When the 6 will be retiring?
35 July, this year.
7?
7, then after...
He is junior to the petitioner, Your Lordship.
Junior.
He is junior. 7 is junior.
Most.
He's a junior
He
most.
is junior most, but
yes,
senior most as per education. His BA, other 2s are intermediate.
But however, Your Lordship, 7 and 6 have been provincialized as a tutor. That means, Your Lordship, both 6 and 7, they do not have the criteria of being a teacher. So it is irrespective that, Your Lordship, the respondent number 6 is HS pass, respondent number 7 is BA pass. But both of them, they do not qualify the criteria of being a teacher. So both of the services have been provincialized as a tutor. Your Lordship, I reserve my right to reply if Your Lordship permits me, because he has not clearly placed the law as well as the DISE data's appreciations, Your Lordship. So I may be allowed to reply, Your Lordship.
He has not produced anything, but I have, without hesitation, without conciliation.
Your Lordship, I'm not the
conciliation,
headmaster, Your
everything-
Lordship.
everything-
I'm just the teacher who has been deprived of his provincialization rights, Your Lordship. Now he's saying that seniority would have to be considered. Then yes, Your Lordship. Then seniority would have to be considered. Then respondent number 7, who is the junior most, his services have been provincialized, Your Lordship. Now that is a stand taken contrary to his own predicament. Your
But he is
Lordship.
the headmaster from the very beginning.
So there
And
is
joining
no
that is
provision in the act, Your Lordship. I'll
Can
just
get
take
rid
your
of
Lordship. I'll just take your Lordship that there is no provision in the act that always defines the headmaster to be provincial. It is the teachers or tutors who have been serving in the school have to be provincials, not as a headmaster, not as a your Lordship, the head of the school. Yes, Your Lordship.
Lordships, I want to submit some citation.
Okay, yeah.
Much obliged, Your Lordship.
Wait, please, Lordship. Lordship, I beg to mention for urgent listing of a transfer petition case number 70 here. Can we fix on Monday, Lordship, because there is some urgency in the case.
Okay, we have.
Because in a trial court, the matter is fixed on 10, Your Lordship. So if it is possible, then 6 or 7, any other date before 10, 7. Highly obliged. Highly obliged.
Lordships, additional affidavit also filed, Lordships, on 38/2024. Lordship, page 128, para number 4. Due dates of 2009-10 and due dates of 2020 and 20 were submitted.
Additional affidavit.
9-10. 9-10. It is start from on 13. On 32. Lordship, on 32, page number 1, Lohit Brahmo. Date of birth 1/10/1971. Classes taught 1. And
You're referring to page number?
2 means language. Lordship.
Page number?
Page number 132. Additional affidavit, Lordship. Filed by the respondent number.
Dated 2nd of September 2024. Additional affidavit of respondent number 6 and 7.
7, yes. Lordship.
Yes.
Lordship, page number 132.
Yes.
Number 1, Lohit Brahmo. Date of birth 1/10/1971. Year of joining in present service 1993. Classes taught 2. It is language. Yanma 1, that is all subjects. Number 2, Thoroni Brahmo. Date of birth 31/3/2067. Date of joining 1993. Classes taught 2. And main subject also 2. What a language teacher and main subject language teacher taught also language teacher. Number 3, Narasandra Brahmo. Date of birth 1/8/1965. He will retire on 31st July this year. Joining also 1993. Classes taught 2 and main subject 2. That means Dharani Sandra Brahmo and Narasandra Brahmo both are language teacher. And only Louis Chandra Brahmo, all subjects including language. As per the DISE code 2009 and 10. But according to the petitioner, paragraph 6, page 8, the petitioner begs to state that Headmaster Louis Chandra Brahma, who is respondent number 7, in this instant writ petition had assigned the petitioner to the social science since the date of joining, that is 1993. It is misleading statement. It is false statement. The form since the date of joining, that is 1/93. But here only start for 2009-10. Earlier there is no use right. So it is misleading statement. And other things, inspection report in the year 2099 and scrutiny committee report 2011, and then these are not denied. His name was in serial list 2. So he was the second senior most teacher. Not senior most, only for the record purpose, he was 2.
So, earlier you have submitted that
Lordship, another thing,
his
Lordship.
name is also recommended for provincialization. On what basis you have submitted the same? So, Pandit,
Lordship,
you have submitted that the name of the petitioner is also recommended for regular, no, for provincialization.
it is in the what 2011. 2011, that is Act as per Provincialization Act 2011, and thereafter 2017 Act. This case is under section 3 of the 2017 Act, Provincialization Services of the Teacher or Teacher. And as per 11 of the Act, 1 science teacher with mathematics, 1 social science teacher, and 1 language teacher. So there is no dispute regarding science teacher, only dispute between language teacher and social science teacher. I am the headmaster, that is respondent 7. I am discharging my duties and teaching social science from the very beginning. Yeah, from 9 to 13 reflects that I am only the social science teacher. Thereafter, another person also rotationally entrusted with the subject of social science, but I am also there. And I am graduate. And respondent 6 is it 2 years more older, is more marked, and he is owner of the school land. His father gifted the school land. Under these circumstances, SMC adopted resolution and he was degraded. That is, petitioner was degraded from 2 to 3.
Whether the school management committee has the power?
SMC has absolute power.
Absolute power.
Absolute power.
Where it is provided?
Well, that not
In the Act?
not brought actually.
In the Act itself?
But it is it is submitted later on, but as we know, that is SMC is the final. SMC decision final, and thereafter
Whether
verified
it
by
is
the block officer
provided
and
in the Act or in the rules. That SMC is the
another
final
thing,
authority.
Lordship, that is section 14 of Assam Educational Provincialization Act 14. As per 14, Lordship, there is appeal power. Lordship 14, appellate authority, the state level authority committee shall be the appellate authority against any recommendation of the district scrutiny committee. If any illegality is done, then the petitioner can appeal to the appellate committee.
So you answer my question.
And the state government of the concerned administrative
On
defense shall be,
what basis you are submitting that the school management committee is the final authority?
Lordship, it will be submitted. Lordship, I have not bought that point, legal provision. Whatever recommended,
We will adjourn the
they
matter
are-
on
No, Your Lordship.
Monday then.
May I just submit, Your Lordship? There is a whole contrary submissions. First of all, in the Act, there is no mention of the school managing committee's recommendation is the final decision. It is the district scrutiny committee which has the duties and obligation to scrutinize the services and records of the institution.
That's all right. Let him substantiate it.
Your Lordship, that would be contrary to law, Your Lordship. Anyways, his submission is not substantiated. The Act does not provide it so, Your Lordship.
We'll see.
Your Lordship, let the matter be heard as part heard, Your Lordship.
Lordship, regarding law point, Lordship, as per the DISE court, it reflects we are eligible for the provincialization.
So my case is also the same, Your Lordship. Even I am eligible for provincialization, Your Lordship. That is the stand, Your Lordship, which has
Another thing
completely
is seniority.
vetoed over the
Regarding
powers of
seniority
the.
also, there is Supreme Court as well as this court.
Produce the judgments before the.
Your Lordship may keep this matter as part heard, Your Lordship.
Okay.
Fix the date, Your
Data,
Lordship.
learning product, public, for the 6 and 7. That is as for, learn setting of for the elementary education part. And who is for BTC? Okay, let him remain present on Monday.
Yes, Your Lordship.
Heard in part, this is the matter of Monday.
Your Lordship may also reflect one aspect, Your Lordship, if I may submit. The respondents shall have to substantiate their legal stand that whether SMC's decision is the final decision or not. That has to be recorded, Your Lordship. Otherwise, again,
May or
they
may
would
not
try
be.
to.
So far I know,
This is not
my knowledge is
this is
concerned.
because the
But I
matter
have
has
to-
been heard substantially, and now they are saying
I
that
shall try to submit.
not try to. He has to produce before his honorable court, Your Lordship. Otherwise, every precious minute of this court has to be
Okay.
withered away, Your Lordship. This is not the way, Your Lordship.
Even though it will not be recorded, then also I will remember it.
Yes, Your Lordship.
Item number 18.
Much obliged, Your Lordship.
My pleasure, Lordship. Also, fight impugn order learned non-ship number 3 at February rejected the application of the petitioner, which was filed under order 1 rule 10 for their impleadment as defendant in the main suit. If you honor kindly peruse first application filed by the petitioner, Lordship will find page number 46, which was brought into the case record by filing an affidavit.
Page number 40.
6. That was separately filed by filing an affidavit. Affidavit dated Lordship 22/9/2023.
Okay.
Affidavit dated
22/9/2023.
Okay. Yes.
If you Lordship will find at page number 46, Annexure A.
40.
Page number 46. That application under order 1 rule 10. That application was filed, Lordship, jointly by Somastavan Bibi, Dilijan Bibi, Moina Bibi, Suratan Bibi, and other legal heir of Kasem Ali. Then, if you honor jointly peruse page number 6 of my revision petition, Lordship, I have draw a family tree.
Page number
6 of my revision petition.
Yeah.
The family tree is there. Lordship, admittedly, the plaintiff is also admitted that the suit property was originally belonging to Dewan Ali. And Dewan Ali has 4 sons and 4 daughters.
Here, Your Honor, what happened? Here, the second son, that is Nasim Ali, he was impleaded as defendant number 2, then Atwar Ali, defendant number 3, and Akhtar Ali, defendant number 3. And then, Your Honor, first late Qasim Ali, his 2 sons, second, Your Honor, Rafiul Haq, he was impleaded as defendant number 5, and Safiul Haq, he was impleaded as defendant number 4. So, admittedly, that property was belonging to Dewan Ali. Plaintiff has preferred this suit seeking decree of right title interest as well as confirmation of possession, at least to be executed on the basis of a sale deed, at least to be executed by defendant number 1, 2, 3, that is Nasem Ali, Atwar Ali, Akhtar Ali, and legal heir of Qasem Ali, that is Rafiul Haq and Safiul Haq. They were impleaded as defendant number 1 to 5 in the suit. If Your Honor kindly peruse then plant of original suit, Your Honor will find page number 12. Cause title, that Nasem Ali, Atwar Ali, Akhtar Ali, defendant number 1 to 3, and the son of Qasem Ali, that is Rafiul Haq and Safiul Haq, defendant number 4 and 5. And in paragraph number 1 of the plan, if Your Honor kindly peruse page number 12, paragraph 1. Subject matter of the suit, Lordship, land measuring 1 because 16 lesser. May I read, Lordship?
Yes.
That land measuring 1 because 16 lessers covered by Kheraz Miadi Patta number 46, Dag number 57, situated at village Kuntisar Part 1 under Circle and District Dhubri, Assam. Next page, Lordship. Had owned and possessed by Muhammad Dewan Ali, alias Dewan Seix, which is more specifically described in the Schedule A at the foot of the this plant. Next, paragraph 2 is vital, Your Honor. On the date of said Dewan Ali, Dewan Seix, the land of Schedule A jointly inherited by the defendants as his legal heir and successors, and they have the title holder of the land. The Schedule A land is the subject matter of the suit, herein referred as suit land. Then, Your Honor, paragraph 3, they have alleged to have executed and sale deed number 1423 of 1997 by the defendant to the suit. Where is, Your Honor? If Your Honor kindly peruse again page 6 of my revision petition, that Dewan Ali has 4 sons and 4 daughters. And interestingly, the plaintiff impleaded elder son Qasem Ali, his 2 sons, Rafiul Haq and Safiul Haq. But
where is the MP on order?
MP on order, Lordship, will find at page number 41, Annexure 5. Effective part, Lordship, will find at page 43. Case is at very initial stage. I filed that application at the stage of issue. Issue is yet to frame. But learned trial court, what Lordship, if you kindly peruse page number 43 from 3rd line. May I read, Lordship?
Upon perusal.
Paragraph 3. In the considered opinion, in the considered opinion of this court, in this instant suit, the question involved are whether the registered sale deed number so and so is valid and binding upon the parties. Next, whether the plaintiff has right title interest of the suit land on the strength of aforesaid sale deed. Upon perusal, it appears that the sale deed in question is executed by the present defendant in favor of plaintiff, and so there is no allegation or any cause of action sought by the plaintiff against the petitioner. The instant suit can be in the opinion of the court effectually and completely adjudicated upon without impleading the petitioners as party to the suit, and as such the petitioner do not appear to be necessary party in the instant suit. Accordingly, this application was decided. If Your Honor kindly peruse my application, I have categorically stated my inheritance right as well as direct interest over the property. In the written objection filed against this application, the opposite plaintiff also did not deny my relationship with the Dewanali. The petitioner number 124, admittedly the daughter of the Dewanali, and petitioner number 529 are admittedly wife and daughters of that elder son of the Dewanali, that is Kasem Ali's wife as well as sons. So kindly peruse my paragraph 1, 2, 3 and 6, 7. I have shown my interest as well as inheritance right in the application, but learned trial court, that was not considered at the time of deciding this application. If you are not kindly peruse order 1 rule 10, that is page number 46, my application, paragraph 1, I have stated regarding original ownership of my father at page 48, Lordship, paragraph 1. In paragraph 2, I have categorically stated about all legal heirs left by
The
Dewan Ali.
question is whether they have asked for any relief against you.
No, Lordship,
plaintiff?
Lordship, if you want to kindly peruse the plan, the learned trial court is going to decide right title interest of the plaintiff. So for deciding right title interest of the plaintiff, the learned trial court must consider the title history of the original owner.
No, you answer my question.
Yes.
Whether they have prayed for any relief against you.
No, against my brother. Against my brother, Lordship. And that my...
No, my question is against you or not.
No, not
No.
against me. But they have suppressed my existence, Lordship. And for deciding, Your Honor, for deciding right title interest, the learned trial court must decide the title of the vendor. So without title of the vendor, the learned trial court cannot decide the title of plaintiff in this suit, Your Honor. For deciding the title of the vendor, we are the necessary party, Lordship, being legal heir of original owner. And being legal heir of original owner, definitely we have direct interest over the suit property.
So trial court has categorically observed that the court can effectually
That's
and
it.
completely adjudicate upon without impleading the petitioners as party to the suit.
If so, Lordship, then the parent petitioner will deprive from getting his right title interest, inheritance right over the suit property. If learned trial court decide right title interest in favor of the plaintiff without giving opportunity
Yes,
to the present
Mr. Kalam, what is your submission?
My submission before Lordship Miller, the failure of the Miller original claim, title suit Miller at page 15 will.
Page
15.
Yes.
Number 1, a decree declaring the plaintiff right title interest in the suit land of Schedule A with confirmation of his possession therein. A decree declaring that the registered sale deed number so and so of sub-registered office duly executed by the defendant in favor of the plaintiff is valid and binding upon them, and defendants have no valid right, title, and interest on the suit land of the Schedule A. That is, my lord, title, interest, and possession as per my lord registered sale deed. They are not denying the registered sale deed. It is rightly or my lord, wrongly, legally or illegally, it was executed. It is executed. They are not objected that my lord, registered sale deed. And I am seeking for my lord, my title, interest, and possession as per the my lord, registered sale deed, which has been executed by the my lord, original defendant. They are not agree. If they are agree, they have to challenge that my lord, title suit. Sorry, my lord, registered sale deed. Then they have to come my lord, in the suit. Otherwise, they cannot. So my lord, the learned trial court my lord, held rightly that the instance suit can be, in the opinion of this court, effectually and completely adjudicate upon without impeding the prisoners as party to the suit, and as such, the petitioners do not appear to be necessary party in this instance. And second submission before Lordship Miller, that Miller instead revision petition filed under section 220, article 227 is not maintainable. If they are agree, they ought to have filed Miller revision or appeal. Because
No,
on the last occasion of my letter, I have
this is the revision petition under Article 227.
But this honorable court held that when revision under section 115 is not maintainable, that only 227 comes. On last occasion, I have written the judgment Miller. It is passed by your lordship. That is CRP IO number 290 of 2022, Ubali Baglari Datta. I have the original copy. Paragraph 11, 12, it is very much clear. Paragraph 11 at page 13 of the judgment. Then
your stand is that the petition itself is not maintainable.
maintainable because my lordship held that, but when remedy for filing a revision before the High Court under section 115 CPC has been expressly barred by a state enactment, only in such a case a petition under 227 article 227 of the Constitution would apply. Otherwise, it is not true. And my lord, where is the wrong? There is no any illegality or irregularity in the impugn order hearing. Here, the maybe the legal heirs of the original patata, but my title interest I am claiming as per my CLD. They are not objected that my CLD. And what is the illegality? It is rightly held that we are not interested party in.
Against reply of first submission, lordship, if your honor kindly peruse page number 21, that is reply of paragraph 3 of the plan, that CLD was categorically denied. Paragraph 21, page 21, paragraph 10 in the written statement. May I read, lordship?
No, not necessary.
Yes, that was categorically denied. And apart from it, your honor, if your honor should kindly peruse paragraph 6 at page 20, paragraph 6 and paragraph 9, the defendant also stated about existence of all legal hair. Paragraph 6.
Maybe, but you see, there are two requirements.
Lordship.
And two requirements have been discussed by the learned trial court
Lordship.
in the last part of the order, impugn order. See, upon perusal, it appears that the cell deed in question is executed by the present defendants in favor of the plaintiff. And there is no allegation or any cause of action sought by the plaintiff against the petitioner. The instance suit can be, in the opinion of the court, effectually and completely adjudicated upon without impeding the petition.
So in this, lordship, some judgment of our High Court is there. This is a recent judgment. Similar case, in this particular case, brother filed that application, and in my case, sister filed the application. Very similar.
Hmm.
2023 judgment that was decided on 15/6/2023. If your lordship kindly peruse paragraph 16 and 17. Very similar, lordship. They are also similar in that case. May I read, lordship?
Not necessary.
Paragraph 16 and 17. That application was filed, brother of the original defendant, who executed the cell deed, Ellis cell deed, in favor of plaintiff to the suit. Joint property, same inheritance right is also there. Here is also this Honorable High Court decided all principle under Order 1 Rule 10, including the principle of dominus legacy.
Numbers of judgment of Supreme Court.
Then in second judgment, Your Honor, this is also judgment of our High Court. When in subject matter the petitioner has direct interest, in that case, party should implead as defendant, at least to defend their right.
We'll see what interest you have in the suit line.
Yes, Your Honor, apparently, if I again want to last submission, Lordship, paragraph 6, the two sons of Kasem Ali as impleaded as defendant number 4 and 5, but wife and daughters were not impleaded. If again, Lordship, kindly peruse the plan, defendant number 4, Rafiul Haq, defendant number 5, Safiul Haq, both are son of Kasem Ali, but wife, Ahiran Bibi, and other 4 daughters were not impleaded.
Okay, with Mr. R. Ali, argument concluded, order is that.
Lordship, this testamentary appeal is preferred under section 299 of Indian Succession Act against the order dated judgment and order dated 23/9/2024 passed in probate title suit 1/2018 passed by additional session district and session judge Kamarongya. Lordship, only the main point is that Mohammedan under serial number 118 of Mullah's laws of Mohammedan law, principle of Mohammedan law, a Mohammedan cannot entirely make will in respect to the entire property. 1/3 only can. That is the provision I will read. Testamentary power. What is the testamentary power? A Mohammedan cannot by will dispose of more than 1/3 of the surplus of his estate after payment of funeral expenses.
You are referring to section?
It is not section, it is serial number. 118 of wills. Under Mohammedan law, Mullah's Mohammedan law.
Principle of Mohammedan law.
Mohammedan law.
Yes.
118.
But some sections are mentioned here.
It is actually Mohammedan law, this law is not codified. It is only a section, they say serial number. Only there are 10 codes, Mohammedan codes, codified.
But in the act itself, it is mentioned as subsection, section.
Oh, Lordship, it is there. But what to my understanding?
Yes, according to your serial number?
118. Limit of testamentary power. Wills, in the case of wills. In my book, it is 127 pages. It may not be same in that.
Whether you have brought this to the notice of the trial court?
Even otherwise also, it was not, I don't think it was brought before the land trial court. So even then, law will prevail. There is a bar, specific bar. Consent of the legal heirs are necessary. So on this point alone, so my
let notice go at this.
Let the appeal be admitted, estimated first appeal, and let the notice go. And we have to stay. There is a interim application also. Otherwise, actually, again, mother and daughters. What is our mother and daughters? And otherwise, also the daughters are respondents are entitled, the petition or appellants are entitled to the SCR.
Heard Mr. Bhagawati, learned counsel for the appellant.
Lordship.
This appeal under section 299 of the Indian Succession Act is directed against the judgment and order dated 23/9/2024, passed in probate title suit number 1 of 2018 by the learned additional district judge Kamru Brahmia. It is to be noted here that by the judgment and order dated 23/9/2024, the learned trial court has granted probate the title suit number 1 of 2018. Of the will of late Soyer Kutubuddin Ahmed in favor of the respondent number 1. Who is the respondent number 1?
Wife of the late Kutubuddin. And interestingly, he died on
Paris the memo of appeal and the grounds mentioned here. And also Paris the impugn judgment and order dated 23rd. Admit. Issue notice to the respondent returnable in 4 weeks. That be taken by registered post with ADA. Then also by usual process within a week from today. Basis shall call for the record from the learned trial court. And considering the submission of Mr. Bhagavati, learned counsel for the appellant. Operation of the impugn judgment and order dated 23rd 9 2024 is then suspended till return after that. It's I. Okay.
Number 20.
Please, it's a appeal against order passed in the title suit number 238 passed by this learned civil judge, senior division number 1, Kamrup Metro. This relates to a case regarding malicious prosecution and defamation. And on the 20 August 2024, after completion of the trial, it was dismissed. And being agreed, the appellant has preferred this petition, appeal memo. Okay, that may be admitted today, and notice may be issued, and there may be called for.
Pardon, Mr. Your good name,
B.
please.
Burman.
Pardon?
B. Burman.
B. Burman, learned counsel for the appellant. This appeal under section 96 1. Read with order 41 rule 1 of the Code of Civil Procedure directed against the judgment and order dated 24 May 24 passed by the learned civil judge in the Guwahati. Title suit number
238.
Yes. 238 of 2014. It is declared that judgment and order dated by the learned trial court has dismissed the suit preferred by the appellant without cost. There is the memo of appeal and the grounds mentioned there. Let notice be issued to the respondent. Admit. Let notice be issued to the respondent. Return for the fee taken by registered post with AD and also by the process which is going on today. Basis shall call for the record from the learned trial court. This is the matter of 4 weeks.
No, there is no IA.
There is no interim day
No.
after 4.
Obvious.
21.
May I please your lordships? I filed the title suit for specific performance of contract, lordship, to get registered sale deed. Trial court rejected my plan, holding that it was filed beyond the period of limitation. Here is the case, lordship. First agreement was executed on 4/12/2018 and extended agreement on 2/1/2020. I filed suit on 6/9/2024. Court held that from the date of agreement 21/2022 and from up to the date of filing, it was beyond the period of 3 years, that is up to 4 years, and ESA rejected the claim on that ground. Here my case is that also, Lordship. In the Bainama also.
So period of limitation is 3 years.
3 years. Here is the Bainama also says after getting sale permission from the competent authority, he will execute. That is one aspect. Another aspect in this
So
case.
the agreement was executed on 21/1/2020.
20. It was
So the
filed on
suit was filed on 6/9/2024.
24.
If the period of limitation is 3 years, then 3 years elapsed.
Elapsed as per agreement. But again, here is the another submission is that, Lordship, during that period, COVID period, Honorable Supreme Court in the Somoto case, case number WBC 3 of the 20, excluded the time period from 15/3/2020 to 28/2020. So after excluding the period, it will stand 2 years, 8 months, 3 days. That judgment I have annexed also. And in the plaint also, it was also specifically stated due to COVID-19, failed to obtain the sale permission. That judgment is at page 31, Lordship, on our FS Court judgment. Tomato case, along with it. The specific direction part is the Lordship will find page 33, paragraph 5, Roman 1. The order dated 23/3/2020 is restored, and in continuation of the subsequent orders dated 8/3/2021, 27/4/2021, and 23/9/2009, it is directed that the period from 15/3/2020 till 22/2022 shall stand as to that for the purpose of limitation as may prescribed under any general or special law in respect of all judicial or quasi-judicial proceedings. Apart from that, Honorable Supreme Court in this judgment, Lordship excluded that period. Even our High Courts also excluding that period.
No, that's all right. You are entitled to. But whether you have pointed it out to the learned trial court at the time of hearing?
No hearing took place after filing of this petition, Lordship. That Honorable Tribunal or learned court below perused the plaint and document. It was first stage. That impugn order is at page, Lordship, 27. Lordship will find.
No, before dismissing the petition, rejecting the plaint,
Lordship,
you have not been heard.
I was not been heard even. I have gone to the case record and note of civil Lordship, second paragraph, fine. It's seen that proper court is paid.
No, that is not reflected in the order.
Order also.
But whether you have not been heard.
Actually,
In
not
fact,
been heard.
In fact.
Not been heard. From procedural plaint and written.
At which paragraph of your petition you have mentioned about the order of the Supreme Court?
Supreme Court, Lordship, in this case, and in the plaint I have not mentioned. COVID period I have mentioned paragraph 6.
Where is your plaint?
Plaint is at page 20, Lordship. Paragraph page 22, paragraph 6, Lordship will find detailed specific statement. And even the extended Bainama, it was also specifically stated after getting sale deed. Paragraph 6, Lordship, maybe.
Not okay, we will remand the matter to the trial court to consider the same.
Yes, sir.
Okay, we'll set aside time.
And IA, along with IA, Lordship, till then, Lordship, I
no, we are
also filed
disposing
an
of the
injunction.
petition today.
Lordship.
We'll set aside the order.
Lordship. Oblige.
We will remand the matter to
Yes,
the
sir.
trial court.
Oblige.
22.
Please, Your Lordship. Lordship, my senior has to leave the court premises due to some family urgency. Kindly adjourn the matter.
Okay. On the prayer being made by Mr.
Yes, Afridi.
Learned counsel for the appellant, dismissal is the matter. When?
On 10th.
10.
10. Oblige.
Please, Your Lordship. Lordship, the counsel for the petitioner, Mr. R. Sensua, had to suddenly go to Sibsagar today due to some family emergency. So he's instructed me to take adjournment today, maybe listed on Monday or Wednesday.
Okay.
Wednesday.
Wednesday. The pair being made by Mr.
G. Kaushik.
Learned counsel for the petitioner. Rest of the matter. Wednesday.
Much obliged.
24.
May it please your lordship. Your lordship, we have filed this appeal basically on the ground of quantum of compensation, your lordship. Here, the learned tribunal has considered the annual income of the deceased as rupees 3,31,984, but claimants have failed to prove the income and occupation of the deceased, your lordship.
Partners.
P. Botakur.
P. Botakur, learned counsel for the appellant. This appeal under section 173 of the DISE directed the judgment and award. Dated 19/2/2024 of the government number and the authors. Intimacy case number 372 of file under section 160. There is a memo of appeal and the grounds.
Lordship, grounds of appeal, page number 6, your lordship.
Judgment and award dated 19/2/2024. Admit. Issue notice to the respondent.
I'm appealing for number 1, 2, and 3. Clement.
Acha. And also her Mr. Talukdar learned for the number 1, 2, and
3.
1, 2. Admit issue notice to the respondent.
There are 4 other respondents.
For
your
which,
lordship.
however, no formal notice is required to be issued to the respondent. 1, 2, and 3. Since Mr. Talukdar learned counsel entered appearance and received notice. However, extra requisite copy of the memo of appeal they furnished to Mr. Talukdar. Step upon rest of the respondent be taken by registered post with ATM to process. Rest itself call for the record for the third attempt. This is the matter under storage. There is stay petition.
Lordship, we have filed a stay petition, but in this case, your lordship, we had already deposited the entire amount, your lordship. That is at a delay stage, your lordship.
We may be allowed to draw 50% of the amount deposited.
Okay. I close.
Lordship of the decision. IC bill number 392724 is filed by RCU.
For stay.
For stay, yes, your lordship.
Mr. Talukdar, your name has not been reflected in the cause list.
In the ISQ, yeah.
In the main case.
In the main case. Okay. I entered a
This is to reflect the name of Mr. Talukdar, learned counsel. 1, 2, and 3, the cause list.
Item 25.
We have been allowed with the
yes.
enter.
Yes.
Obliged. Wait, please, Your Lordship.
Yes.
Lordship, this MSC appeal is filed against the dismissal of the claim petition by the claimant.
Court miss.
A. Bora.
Third counsel for the appellant. This appeal under Section 73, the MDF is directed against the judgment. Against the judgment. An order dated 4/11/2023 hospital for motor claim terminal certificate domestic for domestic for 18/2022 certificate injury. As well as the order dated 23rd/9/2024 passed by the learned member MSCT in this case part 6 of
23.
of 2023.
23. Miscase number 6/2023.
Whether that order is appealable order. Whether that order is appealable order.
That was the order passed in the review petition. Lord.
Whether appeal lie against that order.
We are here regarding both the orders, Lordship. We have approached the Honorable Court claiming the compensation amount, but that was rejected.
The question is whether you can prefer appeal against the order passed in review petition.
Both the orders, Lord.
No, you have to satisfy this court that appeal lies against this order. In this case, number 6 of 2020. Where is your senior?
He is in election court number 21. Your Lord.
Ask him to remain present in the court.
26. Much obliged.
May I please just your Lordship?
Yes.
This is a statutory appeal. Lordship, in this case, the tribunal, learned member came to a clear finding that the insurance company is not liable, and thereafter directed the insurance company to pay the compensation and recover. But Lordship, with the new amendment coming, there is no provision for pay and recovery. Earlier it was there, but now it is not there. And other than that, the other grounds we have taken is 9% interest, but since we are not liable, that ultimately might not be. So
when the case was registered?
Case
before coming into force of the amended act?
Yes, 19. It was in 19 because amended act came April of 22.
Then
A judgment was after that.
Maybe, but the case was prior to amendment.
But Lordship, Lordship, about the retrospective effect. Lordship is talking, but the judgment was passed after the amendment, Lordship. So I think
maybe.
I think this will need some deliberation because the judgment has to be passed as per
old act. The case
No.
was registered under the old act.
Case was registered, yes, 2019. But then since judgment was passed after the passing of the amendment.
That will not cover.
So
Anyway,
we will deposit 50% because otherwise also for pay and recovery lordship, if we go by earlier year, then in Japan that the security has to be there. Those things are to be given. So both
so
ways.
what is the quantum?
3 lakh. 3,47,000.
But when the case will be disposed of, then if your appeal is dismissed, then you have to pay interest more than that amount.
No, Lordship, our appeal won't be dismissed because already the court has come to a conclusion that we can pay and recover. So that already we are protected by that. What we need is, if Lordship says that it was filed earlier to the amendment, then also we have to go by non-Japan case. That the security has to be given by the owner and then only the release to the claimant. So, and if
The date of filing the claim petition.
is examination in chief on epidemic.
Why is there
4012.
awarded amount before that?
Within Lordship, 6 weeks.
No. Okay, 4 weeks.
Highly obliged.
May is then billed by the insurance company. They say only on the two grounds that the injured was traveling in the vehicle beyond the capacity mentioned in the policy itself. As per the policy, apart from the driver, 2 persons are allowed. Now, apart from the driver, in this particular case, when apart from the driver, 4 persons were traveling in the truck, out of which 2 persons died and the other 2 injured. These 2 persons are before your lord. These cases are before your lord. So therefore, one is violation of policy condition. And the second point which I would like to urge is that the vehicle, which is a goods carrying vehicle, had no valid permit. So on these 2 grounds, I'm before your lord.
But Mr. Bhattacharya, can I come to appellant? Appellant against the judge word in this concept. Directed by 1,04,000.
Yes.
full interest, but it was 9% per the date of filing that day. Like, there is a memo that I think that was for it. The it, the, the, there is
I post
IA
yes
50%.
4017.
50% for it.
Yes. My lord, that 4017 is disposed of.
IA
Yes. Same case arising out of same accident. The minor son of the earlier. Yes. That the case number will be 1335 of 50. MSC case number will be changed.
Same.
No.
MSC
MSC case
is
number was
different.
1337. 1335.
Okay.
An appeal filed by the insurance company. In this case, the driver did not have a valid driving license at the given time of accident. Vehicle was a oil tanker. Driver did not have a appropriate reference to drive the
Driver did not the valid driving license.
Yes.
Whether suspect was sitting before the driver.
Yes, yes, the evidence was produced.
Then
DW1, DW1.
who is the DW1?
Kindly see. Error number 31. Now the question is the who is bear the cost of consequence of the plea that there was defect in the driving license. He submitted that the vehicle involved.
No, you tell who is the DW1? Is the investigator?
Is the officer of the company, the administrative officer, not investor.
Nothing. On what basis? That because the driver did not possess valid driving license.
Only our evidence was rejected on the ground that whether at the material point of time the vehicle was loaded with the oil or not, it was not.
It's a possible for establishing that it have to obtain the transport authority. Whether the was obtained.
In this case, right of the third party will be not affected, Lordship. Right of the third party will be not affected, Lordship. Only will get the recovery right from the insured. Since no recovery right was given to us, Lordship, that is why we filed this. So, Lordship, appeal may be admitted and we will deposit 50% of the awarded amount.
But take the potential after that is evaluate the scope, evaluate the content. dated prediction getting paid from night the date of filing realization. There is no web for validity. The need of the also the record the is the record for I report.
Hey, please, Your Lordship. The appeal is against the impugned judgment and order dated 10/9/24 in MSC case number 1453/8, Your Lord, by the learned trial court. Lordship, uh, in evidence.
What are the grounds?
The impugned judgment and order in MSA case number 1453/18 dated 10/9/24 passed in learned member MSA number 3 is bad law as well as in fact of the case and is liable to be satisfied. For that, learned member MSA the Kamrup Metro has failed to appreciate the evidence on record and also overlooked the police report in prescribed from and as well as DD entry, that is Exhibit 1 and Exhibit 2, Your Lordship. Extract copy exhibited by claimant, appellant,
Injury case.
injury case.
Whether you have produced an medical
Yes, Your Lordship, we have submitted medical prescriptions also in claim petition, Your Lordship. Your Lordship, the learned trial court overlooked the GD and police report and passed this impugned order on the basis of the statement of the claimant.
Art your good name?
K. Goswami.
Yes, sir.
K. Goswami. Highly operates.
This appeal is mainly filed on the ground. This was a 17 years boy and parents are the claimant. Dependent is 50%, but here 1/3 has been deducted. And secondly, cost of litigation has been awarded 20,000. Page 22.
So, what's wrong with awarding cost of litigation?
Lordship, on the basis of a Supreme Court judgment, they were awarding the cost of rupees 20,000.
Yes.
That Supreme Court power has been under section 142 of the Constitution. 142 of the Constitution, Supreme Court.
142.
142. But
So,
as per,
no. Whether in that judgment, Supreme Court has exercised that power or
that
not?
power.
That invoke that power.
That power.
Due to the judgment.
Lordship, I have the judgment, but Lordship kindly see 172. 172 of the Motor Vehicle Act. 172 of the Motor Vehicle Act specifically prescribe that no claim tribunal shall pass an order for special cause under subsection 1 for any amount exceeding 1,000. 172 2 only 1,000, that should be with reason. Subsection 2.
Whether this special cost means this cost of litigation.
Lordship. And that has been interpreted in a judgment of this honorable court that cost is under the provision of, because tribunal has no power to giving cost. This power has been given under 120. Tribunal is not a court that has been decided by this honorable. Civil court has the power imposing cost of litigation. Under 227, 226, court can impose a cost. But under 172.
No, Mr. Goswami, the question is the decision of the Supreme Court is binding.
Binding, but
All the court.
that is Supreme Court has stated. Lordship, I have respectfully submit. Lordship also awarded in some cases in MSCP award in cost. I have seen such judgment, Lordship, while in the tribunal also. But that power I have seen in the judgment. Today I have instructed my junior to take this judgment also. He has not brought. Supreme Court has categorically stated on special cost has been given under section 142 of the Constitution.
So it is
I will show Lordship at the relevant time.
what to do.
This appeal is basically on not only cost. Parents are the claimant. Lordship will kindly see page 1, page 22. 17 years boy. Assessment part Lordship will find 1/3 has been deducted. It should be 50%. Secondly, 8,000 has been considered the income, notional income. That should be Lordship as per notification 7,336.
As per notification of
Labor Department, Government of Assam, at the relevant period.
We
will deposit 50%.
But if you have to show that judgment.
I will appeal the case. I will
by exercising the power under Article 1.
I will show the judgment. I will show the judgment.
This appeal is directed against the judgment and award that it directed the amendment herein paid a sum of rupees 17,800. Being the compensation to the respondent with 9% interest per annum. Of and October in for it that it is the record that are is the method I for it. I close this.
May it please your Lordship.
Yes.
Lordship, this MSC appeal is filed against the judgment for the dismissal of the claim petition. There was a mistake committed in the first title, Lordship. Because of the oversight, it has to be dismissal of the claim petition, but was wrongly typed as enhancement of the quantum of award. That was due to oversight, Lordship. I beg your pardon for that.
So you have to correct it.
Yes, Lordship, I will correct it.
I will grant you time to make necessary correction. Or Ms. Boda, learned to Boda appellate. As Tribunal is granted 1 week time to make necessary correction in the post title of the appeal, memo of appeal. Place the matter after 1 week.
Much obliged.
have filed this appeal for enhancement of the awarded amount, my lord. Because the claimant's daughter, she is 8 years old and she has suffered from paraplegia, my lord. That 75% disability. No relief has been given in the head of loss of income and future loss of income due to disability, my lord. Disability doctor has adduced evidence, my lord. She has stated that at present she is a temporary 75% temporary disability, but it may be it must be reviewed every 3 years, and there is no chance of
Improvement.
develop. There's less chance. And there is the
So
learned
whether
member
any
have not.
review was held after 3 months, 3 weeks, no, so 3 years.
Now, my lord, in May 25, 3 years, they again reviewed, my lord.
Review.
Yeah.
Whether that review order was, that review report was produced before the.
Yes, I will produce here, my lord, because there already judgment is passed.
Or your good name, please?
Didi Roy.
Learned counsel for the appellate and also no. This appeal under section 173 of the MD Act is directed against the husband and award dated 18th and 2024 for the learned member for 2009 stroke 2019 is to be noted by the appeal judge award to the verdict directed directed respondent number 1
My lord,
manager pay the sum of rupees 8,50,007 with the compensation to the claim to the appellant here. There is a memo of appeal at the ground mentioned there, and also there is a judgment report. And it issue notice to the response related to the foreign step taken by the expert of AD also. Rest is a call for the record from the learned.
my lord, I have one more pair. Opposite respondent number 2 and 3, they are owner and driver, my lord. This is the enhancement case, my lord. So they are not necessary party. Their name may be stuck of my lord.
Later on, the learned counsel for the appellant comments that respondent number 2 and 3 are the driver and owner of the vehicle, and they are not necessary party in this appeal, and therefore it is not to scrap of their name. Having considered the sum, the pair is then allowed the name of respondent number 2 and 3 to scrap of the post and list list after 4 weeks.
For hearing under order 41, item 34.
Wait, the lord. This appeal is by the plaintiffs, lordship. They filed the suit for right title, interest, and recovery of possession, lordship. The prayer portion I will take, your lordship. Page 14, your lord. 15, lordship. A decree for confirmation of possession of the plaintiffs over the suit schedule A land of the plain. A decree for recovery of first possession of the suit schedule B land by removing the temporary house of the defendant number 1 to 3 from the suit schedule B land of the plaintiffs and delivered first possession. A decree for cancelling the Chita mediation dated so and so, granted in the name of Babulal Bishas and Chiniram Bishas of son of so and so, as inheritance over the suit schedule A and B land and subsequent chita mutation of the said land in the name of the defendant number 4. So basically the case of the plaintiff is that, Lordship, their father's names were recorded in the record of rights, Jogendra Borman, Lordship. So they are the legal heir of recorded patadar over the entire A and B schedule land, Lordship. The name of defendant number 4 was illegally mutated.
Yes.
And defendant number 1 to 3 are the permissive possessor of the plaintiff. So they may be evicted from the schedule B land. This is the case of the plaintiff, Lordship. The defendant number 1 to 3 filed an Lordship written statement stating that they are not permissive possessor of plaintiff, Lordship. They are permissive possessor of defendant number 4. And defendant number 4 filed written statement stating that she did not file any written statement. He admitted the case of the defendant number 1 to 3 and stated that we are the possessing the suit lands on the basis of inheritance, Lord. And this fact was already admitted by PW1 also in his cross that they are also the legal heirs of original Pattada. So, Lordship, the entire suit was dismissed by the learned trial court. The judgment is at page, Lordship will find page 22, trial court decision. The relevant portion is page 37, Your Lord. Three issues are Lordship discussed in paragraph 22. Lord. Issue number 1, 3, and 4, whether the plaintiff has got valid right title interest over the schedule A and B land as described in the plaint, whether the plaintiff is entitled to confirmation of possession over the suit schedule A land, whether the plaintiff is entitled to recovery of past possession over the suit schedule B land. In support of their claim in the plaint, the plaintiff exhibited the certified copy of the Jamabandi, sum of the revenue payment received, and trace map of the suit land. If we go through the documents minutely, it becomes clear that the plaintiffs are the legal heirs of the original Pattada, namely Jogendra Biswas. Thus, they are definitely having right title interest over the suit land. Irrespective of this finding, Lordship, entire suit was dismissed. So my question is that when defendant admitted that they are the possessor of half of the suit patta land, then entire suit of the plaintiff cannot be dismissed. Substantial question of law, page 4, Lordship. Mainly 1 and 3.
So how the first appellate court has dealt with the issue?
Lordship, on the similar footing, that is page 65, issue number 1, whether the plaintiffs are entitled to right title interest over the schedule A and B of the plaint, paragraph 27.
So it was a joint position.
Lordship,
defendant.
our case is that, Lordship, they illegally mutated their name in the revenue records, but defendant number 4 taken a stand that half of the suit patta land they have inherited. So even if they have inherited half of the suit patta land, half of the suit patta land will go to the plaintiffs, Lordship. So their entire suit cannot be dismissed. In written statement, your Lordship will find that they have categorically admitted page 20, paragraph 20A, Lord, that one Horendra Biswas, the predecessor in interest, was the possessor and owner of half portion of the suit patta land, that is measuring 3 kathas 2.5 lesser, and he had been living erecting a house over Dag number 171 till his death. After his death, his two sons, namely Babulal Biswas and Chiniram Biswas, were also living in that house since 60 years back. Chiniram has died without leaving any legal heir except Babulal as his brother. That Babulal Biswas had only one daughter, that is defendant number 4. So defendant number 4 inherited from Horendra Biswas. He is the owner of half portion of the suit patta land. That means, Lordship, the plaintiff have right title interest over half portion of the suit patta.
But source of uh, order is that
Lordship, I have an IA for injunction. They are possessing schedule B.
the day of order
Lord, oblige.
Pending item 25.
In fact, my MSCT petition was dismissed by the learned tribunal member of the tribunal on the ground that I have not mentioned the name of the policy holder, insurance company. But in fact, it was no doubt insured, but while the accident took place, it was expired. That's why without the name of the insurance company, I have filed it, my lord, keeping the owner responsibility. Owner's name was made part. That, but learned member has dismissed that since you have not made party insurance company, that's why it is dismissed. And again, we have filed a review, my lord.
you have also challenged the order.
Yes.
Passed by the learned tribunal.
Yes.
Whereby the review filed by you.
Yes. We have filed again to review, but same was also said that there is nothing to be interfered because it is the insurance company was not involved.
My question, whether against that order, appeal will lie or not?
We have challenged both the order.
Pardon?
We have challenged both the order, impugned both the order.
That's all right. We have challenged both the order, but the question is whether appeal will lie against that order.
Regarding dismissal, I think appeal will lie.
Definitely appeal will lie against the other order.
Against the other order, revision will lie.
Pardon?
Revision will lie. In that event, I have to segregate two cases. That's why we have clubbed both the orders together and filed.
Then is it your submission that we have to take this appeal in respect of one pair and revision in respect of other pair?
Well, in our prayer, we have made that we may be allowed to remand the matter to the court below so that we can continue with the case, impeding the owner of the only. Because their insurance companies will not be responsible since the policy was expired. And I am surprised that how learned member has not also considered the review also. It is a simple matter, my lord. I think there is no bar if we file a case without impeding the insurance company, since there was no insured at that time.
So have you mentioned those facts in your petition?
I have mentioned. That's why we have not made party of the insurance company. The learned member has said that why you have not mentioned.
So
Make part of the insurance company and not maintainable.
No, Mr. Biswas, you tell me what to do in respect of the other pair.
This is a review. My lord, in that your roster is correct. Then in that you have to file a this is revision regarding the review. Then in that case we cannot file this one. Appeal we cannot file now. I may pray that your lordship may convert it to review revision also, my lord. I think your lordship can do it. Or in that event, you allow me to file a revision petition with the liberty.
Are you sure that revision will lie against that order?
Yes, a revision will regarding review.
Yes.
Then in that event, my lord, we will not, we cannot challenge at the moment regarding this appeal, dismissal. If review is allowed, I will again get the opportunity, of course, no doubt.
Okay, we are done with the liberty to make necessary correct memo of appeal.
Yes.
Third, learned of the product. Let the matter after 1 week to enable the business memo of appeal.
Obliged.
After 1.
Item from production list. Item from production list.
Mostly we have come against the order passed by the learned trial court. The order is at page 13, Your Lordship, restraint order, in holding a meeting on 5th of this month, Your Lordship. This is an ex parte order, Your Lordship. Page 13, it starts from last 2 page lines, Your Lordship. This court that order that opposite parties, the defendants, opposite parties are restrained from convening the proposed meeting, Alosana Chakra, which is to be held on 5/1/2015, 2025, Your Lordship. We have come against that, Your Lordship. But the fact of the case is maybe had from the synopsis, Your Lordship. It is, I have very concisely and precisely described the actual metrics in the synopsis itself, Your Lordship. May I read it, Your Lordship?
Yes.
The petitioners formed a committee named Mahapurush Sri Sri Harideva Jivan Darshan Adhyan Committee, Assam, with the salubrious object of undertaking academic research and studies on the life, teachings, ideals, and philosophies of Mahapurush Sri Sri Haridev, a great saint of Assam, and to propagate these to the young generation and to the posterity, and proposed to hold an Alosana Chakra on 5/1/2025 at Guwahati, and to that effect, arrangements have been made, invitations to a good many people have been issued. The respondent organization, namely Uttar Purb Haridev Sangha, has instituted the TS number 380 2024 and the connected Ms. J case number 582 2024 and obtained an ex parte restraint order from the court so and so restraining holding of the meeting on 5/1/2025. The Mahapurush Sri Sri Harideva Jivan Darshan Adhyan Committee, Assam, is an independent committee formed purely for undertaking academic research and studies on the life of the great saint for greater public good, and it has nothing to do with the respondent organization. It is not a subsidiary nor a branch of the respondent organization, and therefore it cannot interfere with the affairs of the committee, and the petitioners also do not aim at interfering with the affairs of the respondent organization. However, the restraint order obtained by misleading the learned trial court has caused prejudice to the petitioners, and the balance of convenience has been totally tilted against the petitioners, as almost all the arrangements for holding the Alosana Chakra on 5/1/2025 have been completed, and therefore huge loss would be caused to the petitioners in terms of money as well as inconvenience to the dignitaries who have been invited to grace the Alosana Chakra. Being agreed, this petition has been filed.
Where is the petition?
That is at page 23. It starts from page 23, Your Honor. Relevant, the submissions starts from page 24, Your Lordship. It is there, petition, Your Lordship.
So the order was passed under Order 39,
Lordship.
Rule 1 and 2, read with Section 151 of the Code of Civil Procedure. and their stay was granted.
Lordship.
So against that order, it is it is an appealable order. Appeal will lie.
This is
So revision will
this is an interim order, Your Lordship, passed in the
maybe even then it is an appealable order. You have to file appeal.
but then Your Lordship, against an interim order,
Maybe
revision is lies, Your Lordship.
it is provided in the act itself. No, sorry, in the CPC itself. Order 43, Rule 1R. You see the CPC?
I haven't brought it, Your Lordship.
Order 43. Rule 1R.
Your Lordship, because the meeting is to be held on 5th, Your Lordship.
Pardon?
Meeting is scheduled to be held on 5th, Your Lordship. Only one day is left.
That's all right, but they have filed a wrong petition.
This petition may be considered to be an appeal, Your Lordship.
Pardon?
This may be considered to be an appeal, Your Lordship, by Your Lordship, and at least
No, you withdraw
at
this
least allow us
petition
to
and file an appeal.
But I am making submission respectively, Your Lordship. This petition may be considered to be an appeal and allow us to hold the meeting on this, and the rest of the proceedings will take part in the proceeding in the lower court, Your Lordship. At least for holding the meeting, Your Lordship. This may be considered to be an appeal, Your Lordship.
So what is the urgency of holding the meeting?
Because some huge expenditure has been incurred, Your Lordship. Many dignitaries have been invited, Your Lordship. That is why. After that, we will go to the
You file appropriate petition, file appeal. We'll consider that. What to do? You want to withdraw this petition or we'll dismiss the same?
But with an observation that appeal may be filed.
Pardon?
With an observation that we may file an appeal.
Third, Mr. Sharma, turn it on for the petition. Mr. Sharma submits that he may be allowed to withdraw this petition, granting the part to file appropriate petition before court. There is allowed with the
Conversely, Your Lordship.
the disposal of withdrawal. However, liberty will remain with the petition. Approach this court again by filing appropriate petition. Have you filed any certified copy here? Certified copy of order? No.
Yes, yes.
The document filed along with the therapy shall be returned to the
One more observation, Your Lordship. If it is so instructed, we may approach the trial court for vacation of that. That may also be observed, Your Lordship.
That liberty will always
But if an observation is made, Your Lordship, that will be convenient.
for the petition. that the granted the court also to approach the learned trial court to make it the appeal order. Here is allowed liberty granted to place the issue to the learned trial court.
Number 35.
Please, Lord. So can you see the last order? Hearing was supposed to be conducted, and hearing already been conducted. My lord. I participated there, but order, my lord, is the white. The second time hearing, my lord. Earlier also hearing was conducted.
Oh, whether hearing was conducted on
Yes, sir.
22/11.
Yes, sir. I have been instructed. Informed
No
that
order has been passed.
no order has been
Till
passed.
date.
And on the last day, my lord, learned counsel for the contender, my lord, submitted that order is the white. They are supposed to produce today.
Yes, so Gogoi, are you appearing for the contempt? Yeah.
No, not at all. It's different.
Yeah, Monday then. Or Monday.
Man, Wednesday, maybe all right.
Third start AF and learning. Non-appeals for the rest of this the matter of question. In the event of subsequent non-appeal now for contempt, the court will proceed here and to the matter on the basis of material.
36.
All right. It is for consideration of interim prayer, my lord. Injunction, my lord. My lord. My lord, here what happened, my lord? We are there in 1960, my lord. Now, the agreement was originally 25 years. Then again, my lord, this agreement was executed in 2008, which was again subsequently 2009. Then, my lord, 3 times, my lord, they were issuing the additional notices. We obtained injunction, my lord. Then again, these were withdrawn. Now they have issued again this notice, my lord, and in the 2008, which is already superseded by 2009 agreement. And secondly, the clause which has been mentioned, that is only in case, my lord, national emergency, if it is required, they can do it. My lord, your lordship may see that, my lord, I'm just referring to, my lord, that agreement. This 2009 agreement also, your lordship may see page 53, my lord. Here the clause, my lord, 16, they are mentioning 2008 also same, my lord, injunction matter. The lessor hereby agrees with the lessor that in case the lessor required a scheduled land for its own use because of any national emergency, the lease may be determined even before expired 20 years. After this agreement also, my lord, that 3 notices has been issued twice, 3 times. And again, these are withdrawn. Now this notice has been issued. If your lordship see the notice, my lord, at page 97. This is, my lord, at page 98, my lord, your lordship will see. Second para. Whereas as per clause 18, release date so and so. This is 2008 they are referring, which is already, my lord, superseded. No, that is also wrong. Provided further release for specific purpose, so and so 60 has been accomplished. Whereas it has been left option for so and so. Therefore, given 6 months notice. So, my lord, this cannot be done, my lord. So, 7 is the last, my lord. That is why we have all the machineries since 1960, my lord. We have plant, my lord, there. We are manufacturing this in the oxygen, my lord. Industrial. So,
let it be on Wednesday then.
My lord, till then, my lord, status quo be minded, my lord, till then. That may be, my lord. Till then, my lord, then how he will be able to do it, my lord.
Around Monday. So there, I'm thinking the not expert in terms of because not granted by the our court has stated, not within the other side, not party. In that order, honorable court also is to the notice. Here, the notice has been the kind of Monday. You have not filed Okalanama today. No, we have filed about. Okay, on Monday then we'll consider that.
My lord, any, my lord, 7 is the last date. That is why, my lord, I am apprehending, my lord. 7 is the last date, my lord. Correct, my lord.
7, nothing will be. Because they are came against the order of the honorable court. Honorable court has issued a material report. Then the Lord honorable court was issued a notice. Again, that they have moved before the High Court also. Because they were Heard Mr. Dean Sayola, learned assisted by Mr. HK Sharma. Learned for the now for the appellant and S. Sharma. Learned also for the response. The Sharma submits that he has filed then he done with some time. Argue the matter. Accordingly, here is allowed with the matter Monday. What is
Liability. You see, regarding Miller title 2, respondent here will file a title suit Miller being 35/2020, and in this case for right title interest, and that was Miller annexure 1, page 13, and we have filed a restatement. In the meantime, during the tendency, Miller, there was a compromise petition filed by both the parties, but avoiding some parts, not everyone, Miller. Then Miller, defendant number 2, Miller, Huni Bhushan, he expired, Miller, and another person was expired. They are not substituted. So, Miller, there is a petition, substitute petition, and there is also Miller pending till date. So, Miller, we file petition against the compromise petition, that is Miller annexure compromise petition, Miller, that is sorry, and Miller impugned order, Miller, that is 14/5/24, by which Miller, our Miller, that compromise, sorry, Miller, the petition was rejected, page 34.
Where is the impugn order?
Page 34, my lord.
34. So at the time of filing the suit, this Joy Kishanpur Mahaprabhu Akhara was not existed.
No, existed. That was existed. That was long back, my lord. But there is a committee, my lord. Some persons, my lord, included subsequently. That is the allegation. So, my lord, they filed petition, my lord, title suit, my lord. And joint petition, my lord, that was filed by Annexure 3, page 29. And that was not signed by everyone, my lord. For person. Page 29, you have to make kindly see. And there was a government party also, my lord. Government is
Yes.
One of the items prior to order 55 before now. At the year 21, one of the court trial court matter for impeachment that was rejected, and there no required 21 another impeachment
is not known.
by one of the petitioner not 42 along with another person matter that was rejected and still order 45 not called and here was 5 1 to 4 they are the there was a compromise after critical of the record they have to put that the two we are they are right in the pilot on procedural they found it or property apart from the Akla minor there the plot of land is already generated by our petition. While constructing the road, our land was thereafter by compromise application was filed to the authority. Thereby, landing a restricted pilot that was nature of the government compromise with the one to four. They filed application that was considered by the court and still order was passed.
Then we'll one thing on suggestion, my lord. Then LCR may be called for. LCR was not called for.
Only to delaying taxes minor. So the proceeding is paid by the he saying that there is 21 2024 minor. There was an order by which the impeachment was rejected. And there is no whisper in their petition minor about that particular order, 21 24 minor. He denying that there is no such order, then my lord I in order I have respect on 21 24 my lord
Then again
file petition my lord which is issued before your lord and in the entire petition there is no not even a statement in the petition itself that earlier because 42 staff was petitioner there.
And that is a LCR is required. Otherwise, I may be wrong or that may be wrong. That may be correct.
There is no whisper about that.
And in the impugn order itself, that is not meant.
It may not be there, but it is on the record. Therefore, he obtained certificate copy.
Maybe, there is a but my party
So if that is the factual position, then you have suppressed the same.
Yes, that is I will be in blame.
If
So that
we
is a
not
the one.
this court with clean hand, then on that ground alone we can dismiss this petition.
There is a my submission will also LCR will be called for so that everything will become more. If my lord, we are guilty, we will be, my lord, then
Why LCR is necessary? He has produced the certified copy of the order.
I am not subject me to that copy also, my lord. Then
You obtain instruction.
I'll take instruction then, my lord, on that point, my lord.
While certified copy is produced before the court, why record is necessary? Mr. Rosit,
No, I understand, my lord.
you obtain instruction from the
I can
your line. Heard Mr. A. Rosit, learned counsel for the petition, and Mr. J. Lutzford, learned number 1 to 7. 1 to 7, and Mr. Gogoi for respondent number 8 to 8, 9, 10, 11. Please the matter on next Friday. So as to enable Mr. Rosit to obtain necessary instruction.
This Friday, my lord. Next Friday.
Next Friday.
Maybe after Bihu, my lord.
After vacation.
Only do another I only think that I make it wrong.
Okay, Friday.
No, he has not been substituted, my lord. My lord, till then, my lord, is to make any.
Till then, interim order passed at September.
My lord.
38.
Made legal lordship. My lord, this is an application for condonation of delay, lordship. There is a delay of 66 days in preparing the appeal. It has come for the first time.
Notice to?
Yes.
Heard means
M. Chudri.
S.
M. Soduri.
M. Soduri, learned from the applicant. This application order under section 5 of the Act is read with section 173(1). Of the MB Act. Proviso to 171. Section 171 of the MB Act is preferred by the applicant for condonation of delay of 60 days for MSC application, connected MSC application against the judgment and awarded at 574 plus the learning to resident claim point. That notice is to the response for the matter after recording.
Lordship, by registered post. By registered post. We'll text him. Or
Both the way.
Both. First of
Registered post as well as
Usual.
usual.
39.
May it please your lordship. Lordship, this IS stands for condonation of delay, lordship, in filing the appeal. Notice may be issued
26 days
26 days.
after provision.
Much.
40.
Repeat your lordship. Lordship, I ask for condonation of delay that I come for the first time.
165 days.
Lordship.
Okay. After provision.
Lordship.
Step by registered post with heading and
41.
My lord, same petition, my lord, delay. My lord.
delay.
Delay.
How many days?
Lordship, here, my lord, 123 days.
120.
42.
Delay application, lordship. 11 days delay.
7 days.
11 days.
11 days.